just take the easy ones. Okay. Good morning, and we apologize for the delay. During the declared emergency in the City of Toronto, Committee of Adjustment virtual public hearings are being conducted by electronic means through WebEx, an online digital platform, and streamed on the Toronto City Planning YouTube channel. These measures are necessary to comply with physical distancing requirements and a provincial order that limits attendance at public gatherings. This will be a virtual public hearing, and participants who have registered in advance will be able to make their presentations to the committee using WebEx, an online event that is being moderated by city staff. Anyone wishing to view the hearing may do so by watching on YouTube. Participants who have registered in advance will be connecting either by their computer, a phone or tablet app, or by telephone. All participants will automatically be muted on entry, and when your item is called, each participant will be unmuted by the moderator, one person at a time. Registered participants will be participating by audio only. Committee of Adjustment members, we have 3 of us in person and 1 participating virtually. That's Laura Alderson, and on my left is Mr. Don Taylor. On my right, Stan Kumaric, and I am Michael Clark. I'm your chair. So we ask if you mute your devices until you're called on to speak. Land acknowledgement. We acknowledge that the land we're meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. In accordance with Sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning bylaw that apply to the property, permissions to extend or alter lawful non-conforming uses, and consents to sever properties to create new lots. Anyone who wishes to receive a copy of the decision of the committee on an application must submit a written request for a decision by email. Please ensure that you include your name, address, and email address, because Committee of Adjustment and the TLAB, in the event of an appeal, will be sending notifications and appeal updates by email. If you don't agree with the decision of the committee, decisions may be appealed to the Toronto Local Appeal Body, TLAB, or in some limited circumstances, to the Local Planning Appeal Tribunal, LPAT. Appeal instructions are set out at the bottom of the decision of the committee. The hearing procedure will be as follows. We'll call each item in the order listed in the agenda, and where an application is uncontested, the agent or application will only make a presentation if required, and the committee may ask questions or take the matter into the committee for a decision. Each speaker, including the applicant or agent, will be given a maximum of 5 minutes to address the committee, and Mr. Kumaric, who's watching the clock, will comment, or I will comment when we are reaching the 5-minute mark. When addressing the committee, please start off by clearly stating your name and address for the record, and please remember to confine your remarks to the matters outlined in the application. In a contested application, the applicant or agent goes first, makes a presentation to the committee. Please note the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application if substantially revised, in order to ensure that the revised application is both accurate and that all those entitled to notice of the application are informed of the changes. Then individuals either in support or opposed to the application, usually opposed, will be invited to speak. Committee members may ask questions of each speaker after they finish their presentations, and when all speakers are finished, the applicant or agent is given an opportunity to rebut only those issues and answer those questions that were raised by the speakers, not to introduce new information. That will then mark the end of the discussion on the application, and it will then be taken into the committee for a decision. Okay, we have some preliminary matters to take care of before we get started. We have the confirmation of the minutes. I don't believe of the last meeting, but the meeting, 2 meetings, I think November the 6th? 5th. Okay, can I get a motion to approve those minutes? Mr. Kumaric, seconded by Ms. Alderson. All in favor? Okay, minutes are approved. Are there any declarations of interest of panel of staff to declare in the applications before us in this morning's agenda? No, none to declare. Okay, files to be closed. I believe we do have a file to be closed. 27 Bala Kane Drive.
Yes, Mr. Chair.
Okay, I think we're getting some interference somewhere. Okay, can we get a motion to close that file? I think we have some materials on that. And there will be no refund for that as well.
Mr. Chair, I'll move that the application be closed.
Thank you, Mr. Taylor. Mr. Kamarick, seconding that. All in favor? Okay. The file is closed, and I guess we'll deal with deferrals and deferral requests as we go through the agenda, Madam Secretary Treasurer.
Yes, sir.
Okay. So in that case, we can get started. Our first application on this morning's agenda is 150 AILEEN Avenue, or AILEEN Avenue. And this application is to legalize and maintain the as-built existing porch, front porch, rear yard deck, and accessory structure to the rear. A previous Committee of Adjustment application granted variances relating to floor space index, side yard setbacks, first floor height, eave setback, platforms, and landscaping. And there are now 8 variances. And yeah, we have the previous decision from March 2018. And we have a order to copies of orders to comply, a previous decision, and we have a memo from planning recommending refusal of the application. Registered to speak on this application is the agent, Faisal Ahmed, and there's no one else ready.
Yes, I'm here. Thank you.
Good morning, sir. How are you?
Good morning. I'm fine.
Okay,
Thank you. How are you?
can we, I guess you've seen the planning report?
Yes.
Dated November the 12th, so they're recommending we refuse the application. So please tell us why we should not do so, and that we should grant the application.
Okay. First of all, I mean, they built already. I mean, they need it because for their family, so they're requesting just a favor so that they don't need to demolish. I explained to the planning committee, I mean, planning member. I spoke to them. I also explained that why they need this. It's only like a few minor variances. They extended a little bit at the rear end, and they widened the front stairs. And yeah, I mean, this is the main reason. Mainly, they need a little bit bigger. So they are really requesting if you can kindly consider this. I mean,
Okay,
it's not, there is no complaint.
can I just, sir, I'm going to just read out for you from the, you're saying they need more room, but this was, what was approved in last year, that was built. Was that built?
It's built, yeah.
Okay, so it says here, planning has discussed the concerns. They feel that the proposed floor space index, dwelling depth, and length do not respect or reinforce existing physical character, possible negative effects for neighboring properties. So they discussed that with you, and you've advised the dwelling and shed have already been constructed and want to proceed to provide us with further clarification. So I need to get that clarification. Their concern still, as it would be the largest proposed FSI in the area. And again, there's been 2 orders to comply, and planning staff have concerns specifically with item 6 on that order, which is dated October 8th, 2019, stating causing the conversion of the existing garage into a habitable space without the benefit of a permit revision. So you're converting that garage into habitable space for someone to live in there, not just to park a car?
No, I mean, nobody's living there, but they made it. I mean, they made a room there. And so number 8, I'm looking at the minimum. Yeah, I'm looking.
So
yeah, they made a room there.
Okay, so you're, first of all, you have to tell us why these variances are appropriate. Planning staff is saying that what they gave you last time is they gave you that approval, and you built beyond the approval.
Yes.
Okay, so you said you want to proceed to us today to give us clarification. Yeah. So what kind of, please provide us with that clarification.
the clarification is mainly they did it based because of the needed. I mean, for the family members, that is the main thing. And the second thing is there is no complaint from the neighbors. I mean, the neighbors, none of the neighbors has any concern. So, and the third thing is actually it's not harming anybody. It's not affecting any neighbors. Yeah.
Well, I don't know about that because
Sorry.
maybe they didn't. A order of comply is usually as a result of a complaint. So you received something. You said they needed the space, but they knew they had to come to committee originally in March 2018. So why did they think they could just build more without having to come back to committee to get committee to give it to them and just do it on their own? So anyway, let's see if any of the other members have any questions for you.
Okay, please. Yeah, thank you.
Anyone have any questions for Mr. Ahmed?
Well, Mr. Chair, I would like an answer to your question. Why, when variances were granted on this application less than 3 years ago, did this construction take place in conflict with those approvals? Could you answer that, sir?
Sorry, second. I couldn't hear it properly. Second, please, if you don't mind.
This property had a number of variances approved in March 2018. Why, less than 3 years later, are you coming here asking for more relief when you already knew what the rules of the relief were as they were set less than 3 years ago? Your client knew full well what the requirements were to build what they allegedly wanted to build less than 3 years ago. Are you just saying, well, their
Okay,
circumstances changed, they need more space, so they just went ahead and did it?
No, I mean the house is not complete yet. They built it, but it's not finished yet.
Yeah,
It's
in
still
October
under construction.
2019, and that's not even now, October 2019, which is just a year and a half after they got the approval, that's when they got the order to comply. So this was already done, not now, but back in October 19, and they were told you to stop building. And I see it's the same, sometimes they say, oh, it's a different order. It's the same owner, the same people who came to committee, or it's not like there hasn't been an intervening sale or anything, correct? It's
No.
the same people we're dealing with. Okay, so it is what it is. And let's
Sorry
see.
about that. I mean, I was not involved in last.
Yeah, it looks like
last
Victor
permit.
Rosa. I just checked. The agent was Victor Rosa, another agent that we. But I don't know when you got involved. But they got that approval.
I just
They
got
went ahead
involved
and
in
did what-
last October.
Yeah, they went ahead and built it,
Right,
but and then they had an order to comply. So obviously somebody complained. Someone saw what was going on. When you say there's no people, don't necessarily have to come forward and complain because they don't like to do that. But it's well beyond what the city says. If you read the planning letter, then they would give you. So anyway, you don't really have any further clarification as of that.
No, I mean this is the main clarification. I'm sorry about that. They did it without the permit, but I don't know when they did it like by mistake or by misunderstanding. I don't know because I just got this in after when they got the stop work order. After that, they came to us, and
Right.
the main what I asked them, why did you guys do that? I mean, they said really we didn't really realize that we needed another room. These, I mean, they also like that's the main thing. What I understood is because of their family need. I mean, requirement. That's why they did it. Yeah.
You see, sometimes people come here and they say, you know, we went ahead and we enclosed our porch, or we did something minor. We built a small addition on the back, and we didn't know we had to apply. But these people made an application through Victor Rosa Planning, came here, got their approval, so they knew. These people did not know. It's not like someone saying, I didn't know. I don't have to do something.
No, I mean, what I understood, maybe Victor, the previous agent or the designing company, they knew it. But what I realized after talking to them, they have very less understanding about the process and everything. I'm talking about the owners. I mean, maybe they didn't realize the consequences.
Okay, I know, Mr. Faisal, Mr. Ahmed, you're doing your best here. I know you're doing your best to support your client. I know you didn't tell them to go ahead and do this. So committee members, any further questions? Or are we ready for a motion?
I actually have a question. You claim that there's nobody currently living in the garage structure. Is that correct?
Yes.
Okay, because that was a particular concern to community planning that someone was going to be living in there. And I'm just wondering, is there any plumbing to that structure, any water to
In
that
that room?
structure? Is there any,
Not in
is
that
there
room.
any water, running water in that structure?
No. I mean,
Okay.
in that particular room, like I went there myself and with another engineer, so we went there. I mean, in that particular room, they made a living space, but there is no like water connection or nothing. It's just like a room. But when we went there, nobody was living there.
Okay,
The other
so no,
side,
no
yeah.
running water at all. Okay, thank you.
Laura, the
Thank you.
garage, I believe, is part of the basement, and on the plans, it's labeled now as a bedroom. So it's not the shed that they're
Yes.
referring to in the back. I hope that helps.
Sorry, second. The shed, yeah.
I'm
yes,
just
the
trying to
shed is
clarify for the other committee member that the garage is an integral part of the basement, which on your drawings, you now have labeled as a bedroom, correct?
And
Right,
not the
right.
shed in the back.
And we're not referring to the shed in the back.
No, I know. I'm talking about the. Oh, right. Okay. And I'm talking about that garage that made as a bedroom. I'm talking about that too. I'm not talking about
Okay,
the shed. Yes.
but that's not what we're talking about, because I believe planning's concern was with regards to what you had originally asked for as a garage, which you have now labeled as a bedroom.
Right. Yeah. I'm sorry. I mean, I don't know if I misunderstood something. What I understood that she was asking that if is any water connection in that garage portion that now we are showing as bedroom. Is that correct, or I misunderstood?
I believe, Laura, you were asking about the shed.
I was
in
asking
shed?
about the shed in the back, yes.
Okay, so
Oh, right. No,
that
there's
was
no
never,
water connection in the shed.
yeah,
The
that,
existing garage.
no, okay, that's not a
There is
garage,
no.
and that was
That's
never
not a garage.
referred
Yeah.
to as a garage, and that is not part of the habitable space. Planning's concern is with
Exactly.
regards to the basement plan, which was formerly referred to as a garage, which is now being referred to as a bedroom.
You also have
Okay.
major variances in excess of what you're granted in March 2018. It's not like it's a measurement issue, it sometimes comes through. You were allowed to build 1.1 times the area of the lot, 301 meters, and you actually built 1.29 times the area of the lot, 354 meters. So an extra 53 approximately meters beyond what you were given permission. That's the main issue, is you went ahead and built, you were granted approvals beyond the bylaw, and you built well beyond that. It's very clearly set out here. So, and,
Right.
so if there's nothing else, is someone ready to make a motion?
If I can make one,
Just one other quick question, if I may.
Please.
You mentioned this was still under construction. Is that, so it's not completed at this point in time?
I mean, it's built, but as they got a stop
Stop.
work order in October, I think. Yeah.
Okay,
So they
so
couldn't
it's still
finish.
not completed.
The finishing is not like the flooring and other stuff. Whatever. Whenever we went there last, I saw that is the finishing is not done yet, because they got the stop work order, so they couldn't continue the work. But they are
Okay.
living in a very bad condition in the basement. I mean,
Okay, thank you.
yeah, thank you.
Looks like I see an order to comply dated April 22nd, 2020, but I have a reference in my notes. Yeah, I thought somewhere it said October in 2019. But anyway, maybe there was 2 orders to comply. I believe there was.
there's two separate orders,
Yes.
or two separate issues.
Right.
Because one has to do with the house itself, and the other is for the ancillary structure.
Right. So that's why there's 2 different ones. But they're very clear here.
Yeah.
Okay, someone ready to make a motion? We're still on item number 1.
I just wanted to wrap up with one final comment, and that is that when this kind of application comes before us, we are asked to look at it as if it were a new application. And from that perspective, I believe some of these variances would be acceptable, but there are clearly some here that are not. And in my view, the variances that are not acceptable and are not within the scope of being minor have to do with the building depth and the building length. And I'm surprised that there are no neighbors here in opposition because of that. But notwithstanding that there is no one here in opposition, it still would set a precedent that I don't think that we could accept. And for that reason, I would be inclined to support planning's recommendation if this were a new application and refuse the application.
Thank you for that motion. Just to clarify also, I think what there also is not supposed to be any inference either for or against the applicant, the fact that it was already built or is already in process of being built. That was perhaps why Laura Alderson was trying to flesh that out. But can it be reversed? It's not completed. So we're supposed to look at it as if it wasn't built. So it's not like we're saying, well, it's built.
No,
It'd be a hardship to have them take it down or comply at this point, or to be punitive. We're in committee now, so you should be muted. You're not supposed to be making any comments at this point. So, having said that, as if it wasn't built, no inference either for or being punitive and saying we're going to turn you down just because you did it without knowing that you were permitted to do it. So there's supposed to be no inference. We look at it as if it hasn't yet been done. So I agree with Mr. Comerc, but anyway, we're in the middle of a motion. So do we have a seconder for that motion? Mr. Taylor, I guess your hand's up as well, Laura. So all in favor? Unanimously, the application has been unanimously refused. Thank you, Mr. Ahmed. Okay, the next application is item number 2. 238 Hallmark Avenue. It's an application to construct a new detached dwelling with an attached garage. There are 3 variances, and there is a map been provided other than the information submitted with the application. We don't have any comments from neighbors or from city departments on this application. And registered to speak is Christopher Zianis. As agent, only one speaker who did not register.
Hello, good morning.
Good morning, sir.
How are you?
We're great. So you have an application for a new house with only 3 variances, 1% more in
That's
coverage, and some gross floor rate 0.64, and no one's weighed in. City departments or neighbors have not said anything. Have you?
No,
You and
I've
your
had
client
discussions
discussed with the neighbors?
planning. Yep.
Okay, I don't think we need a presentation. Let's see if committee members have any questions for you, or if someone's ready to make a motion.
I'm happy to make a motion.
Okay.
I believe the application is minor in nature and desirable for the site. So I'd like to make a motion to approve the variances.
Thank you, Ms. Alderson. Seconder for that motion, and there are no conditions.
I'll second.
Thank you. Mr. Comerc, all in favor? Unanimous approval. Thank you, Mr. Zianis.
Excellent. Thank you very much.
Okay, our next application is item number 3, 24 Park Boulevard. This is an application to construct a new fourplex dwelling and ancillary buildings and structures in the rear yard. There are 5 variances. We have a covering letter from Goodman's. We have a completed Long Branch character guideline been filled out. We understand that planning has a requested conditional approval in the event of approval. They want it tied to the site plan dated October the 2nd. And there's also been some revised plans been submitted. Okay, and Urban Forestry is recommending refusal of the application. Registered to speak is Joe Hoffman as agent, and as well as the neighbors from 22 Park Boulevard, as well as Judy Gibson, the vice chair of the Long Branch Neighborhood Association. Mr. Hoffman, welcome.
Good morning, Mr. Chair, members of the committee. Joe Hoffman, I'm solicitor for the applicant, Columbus Park Developments, Inc., and I'm a lawyer at Goodman's LLP. To start, we did submit a letter late last week after reading Urban Forestry's report, advising the committee that we would be seeking a deferral today. of the application. Leading up to today, we had worked with planning staff, made revisions to the plans, and planning has no objection to the proposal. It's a development that takes an underutilized site that's in need of repair and introduces a 3-story house on the property, bringing much needed rental housing to the city of Toronto. But we have reviewed Urban Forestry's report. Our client has retained an arborist, and our intention moving forward is to work with both Urban Forestry and members of the community. We saw their correspondence. Most of that corresponded related to the removal of trees on the property, and we'd like an opportunity to work with both Urban Forestry and stakeholders in the community to see if revisions to the plans could be made to satisfy everybody. So based on that, sir, we are requesting a deferral today.
Okay, I must tell you, Mr. Hoffman, I can't see that letter asking for a deferral. Maybe I missed it. I saw the original planning, or your original letter when you submitted the application in June, and then your follow-up letter. But I don't see where you're asking for a deferral, but if you want to work.
It is posted on the committee's website. It might have been brought in late, so it wasn't
Anyone else see
found
that?
in your records, sir.
Okay.
Mr. Chairman, it was submitted late, so we didn't put it in part
Oh,
of the
I
package.
see. Okay, there's the answer. Okay. Okay, so we have the other, well, let's see if we have to hear from the neighbor on the issue of the deferral request. Is the neighbor from 22, Mr. Liu, or Ms. Liu there? Sinwei Liu?
I'm here.
Hi. You're the neighbor next door. The applicant or the agent for your neighbor is asking to defer this application because they want to discuss matters with Urban Forestry, because Forestry has written in just recently in November 13th a report recommending that we refuse the application due to the impact on trees. So are you content that this matter be deferred? You will be re-notified. And if there's anything else you'd like to state at this point, perhaps Mr. Hoffman is listening, and if there's any issues that you have to be addressed, perhaps mention them now, because the deferral is relating not to the actual, is relating to the urban forestry concern. We don't have you writing in, we don't have a letter from you or anything indicating that you have any concerns. So do you have any concerns?
I think so far I'm good.
But, okay, so all we're doing now is we're deferring the application, and whether you're okay with him deferring it. Until it's deferred, until it gets back on and approved. If it gets approved, it won't be built. So they're asking just to defer it to deal with that issue. You're okay with that?
Yeah, I'm
no
okay.
hardship on you. Okay. And similarly, Ms. Gibson, perhaps if you're also involved, concerned with the trees, or if you have other issues, but Mr. Hoffman is asking for a deferral to deal with the urban forestry letter.
Yes, this is Judy Gibson here. I'm the vice chair of the Long Branch Neighborhood Association. And can you hear me? Sorry.
Yes, we can.
Okay. I'm fine with the deferral. I would also ask that in addition to addressing the preservation of the protected trees, that zoning and planning also take a look at the lot frontage and the lot area, because according to the survey, the lot frontage is only 14 meters wide. And in an RM zone for a fourplex, it requires a minimum of 21 meters. And that doesn't seem to have been picked up by either the zoning officials nor the planning department.
Okay, so
We also suspect that the lot area is also deficient. So there appear to be variances that are missing in this application as well.
okay, so this will give another opportunity to take another look at that while the matter has been deferred. Because if it's wrong,
Thank you.
I guess everyone wants to know that, because then they'd have to come back in any event. So thank you for that.
Mr.
Okay,
Chair,
so
there's also a letter that came in late from the counselor where he's supporting urban forestry.
okay, so I assume that's now been loaded on the website or the
Yeah, it is on
information
the
center,
file. Yep.
so that Mr. Hoffman can find that if he already hasn't found it. Okay, so on the matter of deferral, we're looking for a motion to defer the application in order for the applicant to deal with urban forestry in light of their letter.
Mr. Chair, I'll move for deferral to enable consultation with urban forestry, community planning, and the neighbors.
Okay, and to deal with this other issue. Okay. it wasn't specifically for that, but probably a good idea, and also to take another look at whether they have the variances properly identified. So thank you. Motion, Mr. Taylor, seconder, Ms. Alderson, all in favor? Okay, unanimously approved. The matter has been deferred. Thank you, Mr. Hoffman.
Thank you, members of the committee.
Next application is item number 4, 2 Weldon Court. And perhaps can you, moderator or host, can you please, I think you have to mute Laura Alderson when she's not speaking because I hear some shuffling. I don't know if anyone else does.
Yeah, Laura, just so you know, if you can just mute yourself when you're not speaking because there's a lot of background interference for some reason on your end. But when you're speaking, it's fine. Just don't forget to mute yourself after you've finished. Thank you.
Or just keep speaking. You don't have to mute it. Okay, this is an application, so we're in number 2 Weldon. It's to expand the existing attached garage by adding a north and east side addition. We have, planning is recommending refusal of variance, the rear yard setback, and something about clarifying the, yeah, I think we need some clarification because they're talking about a rear yard setback, but I think this is an application where the rear is a side and the side is the rear. So perhaps we'll hear about that from the agent, or actually it's the owner, Richard Mio. And
Hi,
that's
good morning.
the only speaker we have.
Sorry?
Yes.
Yes. Yes, good morning.
Can you please
Okay,
just
so-
start off by stating your name?
My name's Richard Mio.
Okay.
I'm looking to widen the garage, that side of the house. You have the pictures that I submitted of the, as well as the site plan?
Yes, we have the site plan for the hearing, and yeah, that's right. That's what, and then we have the planning memo as well as transportation has no objection. No,
So the address
transportation
of
has transportation has a condition of approval, and planning is recommending refusal of 2 of the variances. You've
Right.
seen the memo, sir?
Yes.
Because
yes, I
it's
have.
dated back in August. It's been there for a
Yes, sir.
while. And
Yeah.
they want us to review variance 2, the rear yard setback, and the building length.
I think
But I
that's,
do note by looking at the location map, I don't know if that's any, provides any, explanation for you that you're basically a corner lot. So I don't know if that's a mitigating situation. Transportation is in favor with some conditions. So would you like to just explain to us what you're doing here and why it's appropriate?
okay, so the basic, what we're requesting is to widen the garage to approximately 1.2 meters from the property line on the left side, which would be the west side of the property. The garage, if you look at the picture, you'll see that the driveway has a substantial swale slope up to the door. We'd like to lower the garage so the driveway doesn't have that much of a slope to it. It gets a little tricky sometimes in the wintertime. And that side, the left side of the house, when you're looking at it from Burr, is relatively unused, that space there. We're looking for a wider garage, basically. And I know the address is 2 Weldon Court. And, when you're looking at the house from 2 Weldon, I can understand the building department saying that the house is too long. But when you situate the house, looking at it from Burr, the front of the house is really facing Burr and not Weldon.
Yes.
And having said that, that kind of changes all the first 4 issues of their, there, where the depth of the house is only, I believe it's about 8 meters instead of the 17 or 18 meters that they say is too long. And that changes the depth of the backyard is really, I don't know, approximately 6 meters, give or take. And it's I don't know, 90 meters wide, give or take. So, sorry, 90 feet wide, 27 meters, give or take. It's not, it's not the 1.2 meters or the, sorry, the 2.4 meters depth of the backyard. It's, so do you understand what I'm getting at?
Well,
with
certainly I'm
when you
understanding,
say-
as I stated at the outset, the whole problem with your lot is because you're the corner lot, you're really fronting onto Burr and not onto Weldon Court. Your house is the opposite way. So
Well,
as a
if I were-
result, you're gonna have, but they are concerned with you read the planning memo, they're concerned with I guess, the rear yard setback and the length, but without that, you're,
if I were to change the address to Burr Avenue, then those first four items wouldn't be an issue.
correct.
Right.
Okay, let's see if committee members have any questions for Mr. Mio.
So I'm assuming that your main interest is to widen it, not necessarily extend the depth of the garage.
Right.
So if you were to get the widening, you'd be okay with not getting the depth.
Yes, I would like the depth as well, just to, so I can get two cars in there, because right now it's like just one car will fit.
Okay.
And I could, if by extending it, I can get like a tandem garage there. So I can get two small cars in the garage.
Because maybe I'm turned around on this, but I thought that planning's concern was with the depth of the garage, not with the width of the garage.
No, I think their concern was the depth of the house altogether. It would have been too long. My understanding is that the maximum is 17 meters, and then it would get extended to 18 meters if we're.
Oh, okay, okay. Yeah, I don't have a problem with that.
Okay, any other questions, or is someone ready to make a motion?
Mr. Chair, I find the requested variances meet the four tests under the Planning Act, and I would move for approval subject to urban forestry condition number 2 and the conditions of the Transportation Department.
Okay, thank you, Mr. Taylor. Seconder for that motion. Ms. Alderson's hand went up first, so she seconded. All in favor, unanimous approval. Thank you, Mr. Mia.
Okay, thank you.
You have approval.
Thank you very much. Have a good day.
Okay, moving on to item number 5, 443rd Street. This
Yep.
is a
Hello.
detached dwelling with a new detached dwelling with an attached garage, and there are 7 variances. We have Long Branch character guidelines. We have street elevation been provided. We have a memo from planning, just as a report for information, and we have Metrolinx conditions of approval, and TRCA has no objection. Speaker for this item is Nick Sacconi, the agent, and he's the only registered person on this application. No one else is registered to speak.
No, Mr. Chair, the Metrolinx comments are very vague, so I'm not sure if the applicant can address how they would feel about that as a condition, maybe.
Okay, Mr. Sacconi?
Hello?
Hello.
Yes, hi. Sorry about that. Yes, I could address the Metrolinx comments. I've essentially one of the variances here is a front yard setback. So initially, I had designed the house and positioned it so I didn't have this front yard setback. So TRCA requested me to push the house further up in order to, I guess, conform to their certain distance requirements from their track to the back of my house.
Mm-hmm.
So this was already issued, or this issue was already dealt with by me shifting the house forward and creating the variance. This particular lot, it was kind of a challenge because there's ravine, which I've satisfied, TRCA, which I've satisfied, Metrolinx, which I've satisfied, and also planning. So this specific design was molded by going back and forth to all these different, I guess, bodies, if you want to call it that, with their input. So regarding your question, I moved the house further up, and the planner, city planner, acknowledged that she was okay with by me moving it up because of Metrolinx's request. So I've already did whatever Metrolinx wanted by moving the house up.
Okay. Does anyone have any questions for Mr. Ciccone?
Yeah, I have something in my notes that says Metrolinx objection, but will withdraw if owner executes and registers on title and infill adjacent development agreement. Can you tell me about that?
Yeah, so they wanted me, because as I said, initially the house was pushed back.
Right.
And I sent this agreement to my lawyer, and my lawyer goes, don't sign it. Just like, what do they want you to do? I said, push the house up. I said, but if I push it up, I got to redo a zoning review, which would take time, which I didn't have, but I ended up doing it. I ended up saying, okay, fine. I don't want to sign anything if you're telling me not to sign it, but I want to make these guys at Metrolinx content. And I want them to basically write an approval for my lot. Like, I don't want to go through hoops here. So he goes, well, then I have to resubmit, get a new zoning review, bring it back to the planner. So that's what I did.
So you're telling me that Metrolinx is not asking you to sign that agreement then?
Once, so that signing of the agreement was for my initial submission of the house pushed back. Ever since I've signed, ever since I've resubmitted or revised my application, they never sent me anything else back saying I have to sign it.
They've sent it
So,
to us.
But they also haven't waived it.
okay.
Or have they?
I never got anything. So essentially, when I spoke to them, their request was to essentially like move it move it back because they were scared of, I guess, of a possible derailment, and it kind of, they needed a certain amount of space, like
Right.
between
Oh, I
the back
understand
of
what
my
you're
house.
saying, but you haven't heard from them. Is that
I haven't.
what you're telling us?
So the
You haven't
comments
heard back
from
from them?
Okay, the issue before us is whether, as Metrolinx requests, we have one at staff, they're asking that we include a Metrolinx clearance as part of the conditions of approval. We already have the planning report, planning's not asking, TRCA's not asking, but Metrolinx is. So that's the issue. Do we have, and you're saying because it's vague, do we have a concern of imposing a condition that is then vague? Although in that case, you're just saying a clearance. So in other words, basically that would say that they're in charge if they give a clearance, as opposed to, it's putting the whole thing, our approval being subject to Metrolinx saying yes or no.
which ties the applicant up significantly.
Right.
because
Yeah,
if
I've
there's
got a
path
problem with
forward-
that because we don't know what it is, what condition we're
Yeah,
imposing.
it's not
because
like
Metrolinx
typically it
hasn't
says
told
you
us
shall
what they
do
want.
A, B, and C, and we know it's A, B, and C. But here it just says making it conditional on an approval, and we don't know what what A, B, and C, D, and E, and F was in order to
Yeah,
get that.
it should be specific.
that
The comments
clearance.
from Metrolinx are dated October 2nd, and the applicant did submit revisions on October 26th. So in my opinion,
Correct.
the Metrolinx comments are out of date.
Okay.
They haven't provided us with new comments,
So let's ignore them.
and that
Yeah.
condition is too vague. It
Yeah.
ties up an applicant
Unless
for
we
any
said
host of
we're,
conditions that they're not aware of in advance.
so it's sort of like planning, we'll take this for information. Just like planning is giving us sometimes memos for information. And they've actually dealt with it, so there is sort of some relevance because they do mention that in their report. Okay.
Should I just ask one more question? Madam Secretary Treasurer, could Metrolinx require a clearance whether we impose it as a condition or not? Do they have that authority regardless of us?
That would be up to Toronto Building to determine if they have rights in terms of applicable law when they issue a building permit. But then that would apply to anyone in that circumstance.
Yeah.
Whereas if you impose it as a condition, the applicant has no way around it and can be held up indefinitely until Metrolinx is satisfied. And may mean signing an agreement that he doesn't want to.
So for our purposes, which is planning, dealing with the minor variance, it's not like they're saying do A, B, and C, and we can say, yeah, A and B are reasonable, C isn't, so we'll approve them. But here they're not asking for conditions, they're just saying.
You're giving
make
them a
us-
blank check of approval.
Yeah, exactly. Okay.
And
Okay, so can we have a motion then?
I'll move a motion. I'll move a motion for approval, subject to forestry condition number 2 and nothing else.
Okay. Seconder for that motion. Mr. Taylor, all in favor? Okay, the application is unanimously approved with no condition on the Metrolinx issue. Okay, Mr. Sigoni, you understand
you.
what we've done here?
100% understand.
Okay,
Thank
sir.
you very much. Have a
Okay,
great
good
day.
luck. Thank you.
Thank you. Bye-bye.
Okay, so moving on to item number 6, 126th Street. And this is an application to maintain the second secondary suite. There are 3 variances. We have supporting material and the Long Branch character guidelines. Planning is recommending as a condition of approval that there be only 2 secondary suites, just to make sure there's not going to be, you're allowed 1, they have a second one. So planning is suggesting the approval is subject to no more than 3 dwelling units in any type of form at the subject property. So I guess they're closing the door on any further applications for any further suites. And registered to speak on this is Frank Bellini, the agent who, again, did not register. Please register next time. Mr. Bellini?
Okay, forgive me,
That's okay.
yes, can you hear me?
Yes, we can hear you loud and clear.
Okay, should I speak now, or can I?
Sure, go ahead,
comment
go ahead.
on my I think it's pretty straightforward. My client purchased this property, and there were some illegal suites there. Actually, there were 4. One was in the garage, and he's trying to legalize it and have in total 3.
Yep.
As you see in the report, I think we are in agreement with what the planning suggested, and I'm here to open to hear any
Okay.
questions.
Okay, so Frank, let's see if committee members have any questions or if we're ready for a motion and you're okay with the condition from planning.
Yes.
Okay. Any questions for Mr. Bellini, or are you ready for a motion?
I believe the application is minor and meets the 4 tests. I would therefore like to move approval, subject to planning condition that no more than 3 units be allowed at this site.
Okay, thank you, Mr. Comerford. We have a seconder for that? Mr. Taylor? All in favor? Unanimous approval, thank you. Subject to the condition. Okay, item number...
Thank you very much.
You're welcome, sir. Item number 7 is 22 NEILOR Crescent. It's an application for a new detached dwelling with an attached garage. There are 4 variances. Huh, I missed that. We have a planning condition of approval, TRCA, and have no objection, ravines. And there's an urban forestry application, I believe, to injure a tree. Is that I don't have, does anyone have see what the urban forestry is on this? Or an urban forestry condition?
No conditions.
Yeah, I didn't have any yeah, planning has a condition on bird-friendly treatments. Anyway, the speaker is Jim Kim. Only 1 speaker registered, no neighbors registered to speak on this application. Mr. Kim?
Yes, I'm here.
Welcome.
Thank you. Good to hear it. Yeah, just the four variances, we think they're relatively minor. And as you mentioned, planning and the TRCA have no objections. Urban forestry also has no objections, no conditions.
Yes.
And yeah, and pretty much that's it. What's before you? Yes.
You had a question for staff. That was I couldn't see in my notes. The lot coverage permitted is 33%. You are at 33%. However, you're over by like 0.2 of a meter. So it's a very interesting variance for 0.2 of a meter at the same percentage, but a slightly different square meters.
They rounded up for us, I think.
Okay. Any questions for Mr. Kim, or is someone ready to make a motion?
My understanding is that there is a concern from Ravine, and I'm just trying to find that right now.
Application to injure it, yeah.
No, Ravine had no comments.
No comments.
No comments.
Mr. Chair, I find the variances to be minor in nature and meeting the other tests under the Planning Act as well. And I move for approval, subject to the conditions of the Planning Department.
Okay, thank you. Mr. Taylor seconds that motion. Laura Alderson, all in favor? Unanimous approval. Thank you, sir.
Thank you very much. Bye.
Okay. Item number 8 is 3 Hartfield Road. This is an application to construct a new detached dwelling with an attached garage. There are 9 variances. Seeking to go from like 33% to 41% coverage. Planning is recommending refusal on the basis that it's overdevelopment and not in keeping. And we have letters from 1, 5, 7. We basically have several letters, urban forestry conditions 2 and 5. And objections from neighbors at 1, 3, and 7 Hartfield and 1220 and 1222 Royal York. And from 3 Southway Road. Registered to speak on this application are Paul DeMello as agent, as well as the neighbor at 1 Hartfield Road and 1222 Royal York Road. So those are 2 of the people who've written in to us of the 4. Mr. DeMello, welcome.
Yes, good morning, Mr. Chair. Good morning, members. Mr. Chair, I had advised committee yesterday that we would be seeking a deferral, given the comments that have been received by city planning staff with regard to this. My client's looking at making some possible revisions to the drawing, and I can advise that in particular, one of the revisions we're looking at making is the loggia at the back of the house, the removal of that. That reduces the overall lot coverage. It reduces the issues with regards to the depth of the house, and also with regards to the second-story decking at the back. Okay. So it would address a number of variances, either eliminating them or severely restricting them.
Okay, and perhaps you can include the neighbors. We have the 4 directly affected neighbors, 5 actually, 1, 5, and 7, and the 2 behind. Two of which are on the line with us right now, and perhaps you can, as well as, in addition to, they'll be served with new notice if this gets deferred and comes back after you made changes, but if you could perhaps consult with them as well. Committee members, any questions on the matter of the deferral, and perhaps we should speak to the neighbors. 1 Hartfield Road, Elizabeth Zucchiatti?
Yes.
Welcome. So we hear that the applicant is asking for a deferral to deal with the issue with the recommendation of refusal from community planning, as well as we have your and the other neighbors' letters. Are you okay with the deferral?
Yes, absolutely.
Okay.
I just wanted to bring up one item, was that there's a significant tree in the back that was not noticed on the application, and it also wasn't addressed by forestry.
Okay, I know there is a memo. Forestry is looking for conditions 2 and 5. 5 is a refusal, and I guess 2 is like a follow-up. If it got approved, even though if they said they recommend refusal, that would allow them to bring an application to injure the tree. I don't know if that's the tree that we're talking about, but that's something perhaps that Mr. DeMello, who's listening, can deal with before we get back here as well. to deal with urban forestry, and as well as to just read the letters from the neighbors, and hopefully those concerns are dealt with what he's planning to do as well.
Great, thank you.
Okay, and Jessica or Norbert Newtel at 1222 Royal York.
Hi, yes. Yeah, I'm also okay with a deferral, and just like Elizabeth, just making sure that it's the tree in the backyard that's addressed versus the tree at the front. That is a big concern. Then, of course, the other variances. But yes, the deferral sounds good.
Okay, and you're Jessica Newtel for the record, correct?
Yes, I am.
Okay, thank you. Okay, committee members, we have a deferral request to deal with the negative planning report and the other letters of objection, to deal with the issue about the tree at the rear. Can I have a motion for deferral, please? I see Laura's lips moving. There you go.
There we go. I can make a motion for deferral in order to give the applicant an opportunity to speak with community planning, as well as the neighbors, and as well as urban forestry.
Okay. Thank you. Seconder for that, Mr. Taylor, all in favor? Okay, the matter has been deferred. Thank you, Mr. DeMello.
Thank you, Mr. Chair. Thank you very much.
Thank you. Okay, now the remainder of the items this morning are items that were deferred from previous hearings. So the first one is item number 9, 5 Gaylord Avenue. That was deferred from the February 27, 2020 hearing. This is for a detached dwelling with an attached garage. There are 4 variances. We have a covering letter dated September 2020. We have revised front driveway, changes to the exterior elevation and the roof configuration. This matter was adjourned to consult with urban forestry. Also, the applicant advised was to consult with the neighbors. And we have 7 letters of support. We have opposition from 3 and 7. And we have urban forestry requesting conditions 1 and 2. And there's adjacent tree impact. Registered to speak on this application are both the agent Peter Giordano, as well as both adjacent neighbors at 7 and 3 Gaylord. So let's get started. Mr. Giordano.
Yes, hi.
Okay. So please just state your name and for the record, and give us a presentation why this application is worthy of support. And let us know if you've consulted with your neighbors at all, because both adjacent neighbors are here.
Yes,
and
of course.
Advise of what's happened, I guess, since the last hearing, because this matter was deferred as well to deal with the here. Provide the application an opportunity to consult with urban forestry and the area. Okay.
Yes.
Okay.
Okay. My name is Peter Giordano. I'm with David Small Designs, 1405 Cornwall Road in Oakville. I'm the authorized agent for the application. As you've already stated, the application was originally deferred from February 27th hearing to address concerns from the neighbors. Since then, changes have been made to the architecture to remove or reduce variances and address concerns. My clients have had numerous discussions with neighbors and have appeased what we believe to be most of them, backed up by the 7 letters of support. Most concerns were related to control of water, as the natural topography of the lot, primarily a split drainage which slopes from the front of the house to the street, and then from the front of the house to the rear of the property. Lot grading certification will take this application through an extensive process to ensure that water is controlled on the subject property as per municipal guidelines. Remaining concerns from the neighbors appear to be more related to the pool than to the house, but I know there are 2 here to speak to that today. As you can see, if I can ask Paul, the moderator, to display my my presentation slides.
Yep.
If you go to the second slide, Paul. Second slide. The one above. Okay, so this is the front of the house, 3D of the front of the house. It's primarily a traditional house from the facade at the front. Next slide, Paul. It primarily, it's 1.2 meters on this side. This is the right side. Next slide, Paul. On the rear, it's well articulated, and we have an aggregate side yard variance, which you can see is addressed on the left side here by stepping the house back. It's basically a third at the front. That's a variance, and then it steps back 2 steps. One of the variances is building length. Part of that is this projected porch that you could see at the rear of the property. Because this porch has finished space below, it is included in the building length. Otherwise, if it didn't have a finished space below the porch, subterranean, it wouldn't be included in the building length. Next slide, Paul. Left side elevation, you can see more articulation. Next.
Yeah.
This is the context of the adjacent properties, the houses on either side. Looks like we have reference attendance from number 7 and number 3 here today. Next. Just some more visuals. There's a school across the street. Next. So this is itemized variances. I have the items listed from the zoning notice, so they're slightly different than what's actually on the hearing notice. So I'll go through them with the proper numbering from the hearing notice. We have 4 minor variance requests. The first of which is an increase in floor space index. We're allowed a maximum of 0.5, and we're asking for 0.58. The house less the garage is 4,016 square feet. Variance number 2 is for an aggregate side yard, as we just mentioned. The house meets the 1.2 meter minimum side yard setbacks, but falls short on the combined aggregate of 3.32. We're providing 2.59 at the front, but again, as you can see, it steps back twice. So the front third is really the aggregate side yard variance, and the next 2 it steps back. Hence, it minimizes the impact of the variance. Item number 3 is for building length, as I had already mentioned. The building length, as you can see, I have them itemized as item 1 and item 2 on this plan. You can see that the building length is from the front of the house to the back step projection of the porch. So it's not only the porch, but it's even the step projection. And then the building depth is taken from the minimum front yard setback, which we're back of that just slightly, to the same step projection. If you actually look at the building, at the largest building depth without the porch projection from the front wall of the house to the furthest most projection of the back, we're only 17.68 meters in length. So that's basically variance 3 and 4, which is building length and building depth. My clients have addressed, I've lived at this address for many years, love the neighborhood. We've met with neighbors individually and went so far as to invite the neighbors to the schoolyard across the street and have an open conversation. Attended by 3 neighbors. In attendance were number 3, number 9, and number 17.
Okay.
We understand planning staff have no concerns of our application. We acknowledge and accept the urban forestry conditions for the approval to injure trees. Ultimately, we believe our variance to be minor, past the 4 tests. Thank you.
Okay, thank you, sir. Okay, now anyone have any questions before we move on to hear from the neighbors? Okay.
I could have a question. Given that some of the variances, or the nature that you've described the variances, I'm assuming you wouldn't have a concern if a approval, should it happen, would be tied to your current drawings and/or site plans?
Oh, absolutely not.
Yeah.
We would intend that to be the case.
Yeah, it's sort of giving you what you walk through and at the length, and it's not throughout, it's tied to your particular site plan and for the purpose of, it's good that you agreed to this. Let's hear what the neighbors, if they still have concerns. I know they were present and they were involved. And so let's hear first from Laura Hearn or Paul McDonough at 7 Gaylord.
Okay, I think Camilla was going to go first, speaking of the water issue. I know
Okay.
you don't want to hear
You want
or
me to hear from
repeat
Camilla
a
first? Sure.
situation.
Okay,
Yeah,
I'll
I
hear
will
from
be
her
speaking
first.
on the other subject.
Okay, thank you. Camilla
Okay,
Vaz,
thanks.
3 Gaylord.
Yes, thank you. Good morning, Mr. Chairman and committee members. My name is Camila Vaz, and I'm speaking on behalf of my husband, Jitendra Tide. We live at 3 Gaylord Avenue, adjacent to the applicant on the east side.
Okay, so
My
he supplied us with a photo here. So we see you're on the left side of the photo. Both houses are double garage,
Correct.
relatively new homes. So perhaps you can also tell us what. Let's hear your concerns.
My concerns, as indicated in my letter to the committee at the initial hearing in February, remain the same. And I apologize if I am repeating myself. My property and number 5 both slope south along the length of the property. And as indicated by the Mr. Giordano, there is a large schoolyard and park north of Gaylord, surrounding Wedgwood Junior School that slopes towards Gaylord Avenue. And Gaylord in turn slopes south towards our properties and east to the start of the street, namely number 3 and number 5. Gaylord Avenue acts as the base of a T with the tail running between the two properties, number 3 and 5. And during extreme weather events, especially rain, like the flooding in 2013 and 2019, there occurs a torrent of water running between the two properties. So far, we at number 3 Gaylord have not experienced any flooding during our residence here over the last 18 years. This equilibrium, I believe, is soon to change from an area with a large permeable surface to one that is much reduced. First, the side yard setback on the east side is the narrowest at the area we believe is the most vulnerable and needs to be preserved. The hardscaping is also the most intense on the east side, as shown on the proposed plans. The backyard plans also show a proposed pool and deck that further decreases the overall permeable surface area. During my 2 conversations with Mr. Sedgman, he has suggested that water management is a landscaping issue and not connected with the variances requested today.
That's true.
I am uncertain if this is true entirely.
Yeah, ma'am, we actually
also
don't deal
believe-
with just to let you know, we don't deal with really grading and drainage issues, but just with the built form typically, and we acknowledge that there's larger house, less area for water drainage. You and your neighbor at the other side both have, I'd like to hear how the size of your homes compare to the size of this house as well. Perhaps it's been a little bungalow there for some time now, but just like you and the other neighbor at 7, you want to have built more substantial homes on the site. So the issues of there are obviously, as you say in your letter, even, trenches and weeping tiles and those, there are French drain, there are ways to deal with this, but it's not something that we typically get into.
So we were requesting that the committee reconsider the side yard setback, especially on the east side, and the hardscaping on the east side of the proposed building, and also requesting an engineered solution to address the water runoff, especially during the building of the proposed dwelling to meet the increased requirements during extreme weather events. Should this committee see fit to approve the plans? My worry is that we will be left to deal with the consequences of this water management problem should the approval be given to the plans as they currently are. Thank you for allowing me to address my concerns to you.
Thank you, Ms. Vaz. Question for you. What about, does your side yard on that side, and actually on the other side as well, do you comply with the bylaw?
Yes, we are about 1.5 meters.
Uh-huh. Okay. Did you bought your house? You built your house? You've
I
been
did
there-
not. We bought the house. It is about 25 years old.
Okay, so that is, even though it looks relatively new, you're saying it's a 25-year-old house.
Correct. We've lived here for about 18, and it was already, we were the third owner.
Okay. Okay, thank you. So let's go back to Laura Hearn then at 7 Gaylord. Thank you.
Square footage of number 5, you mentioned 4,000 square feet of living space. Our house is actually only 2,700 square feet by the look of it. So when I see the drawings there, the interpretation, it does look similar in size, but that is quite a difference of 1,300 square feet. Anyway, just wanted to let that known. But thank you for your time today. I'm Laura Hearn, and along with my husband, Paul McDonough, we've lived at 7 Gaylord for the past 25 years and are the immediate neighbors to the west side of 5 Gaylord. I just wanted to say we are in full agreement with the concerns that our neighbor at number 3 have expressed with the matters of the water runoff and drainage, and yes, you've explained you don't deal with that. I'll be speaking about those cedar trees along our property line and to hopefully convey how they are important to us and the integrity of the area. These trees provide a source of privacy, shade, and greenery to our space, not only for us, but the abundance of wildlife in the area. They have been growing here since the neighborhood was built. To lose them would greatly affect our enjoyment of our backyard. We've consulted with a certified arborist and have submitted their assessment regarding the proposed construction at 5 Gaylord with the minor variances requested. We filed the 3-page report on November 16th, along with the letter outlining our concerns, and they are attached to the file. In October, I did ask where I could review the arborist report that is listed on the submitted plans dated July 20th, 2020. They weren't submitted until November 19th to the list of documents, so I've only had the past day or so to read over them. We see an injury permit is to be required for the trees and others in question. I would rather that it be a protection permit than an injury permit, but what's to say that? As there's not a guarantee, these trees won't have been damaged, and it may not show for a few years, as stated in the WELDON Consult arborist report they've submitted. We feel the setback, dwelling length, depth variances being requested will impact on the trees when excavating the dwelling and the proposed in-ground pool by severing roots and causing stress and damage. As in our arborist report, it's recommended to relocate the window well on the southwest side to better protect the trees listed as 6, 7, and 8 on the site and grading plan. Also noted in our arborist assessment is a recommendation to redesign the pool as trees listed as 6, 7, and 8, and the proposed fencing shown on the site and grading plan is not adequate to protect the roots. The reason we've commented on the proposed pool at this time is that when and if a building permit is issued, the pool will be excavated at the same time as the dwelling. We hope that our arborist assessment submitted lends value to our concerns of the variances and proposed plans being requested for the dwelling at 5 Gaylord Avenue. I appreciate also noting that the arborist consultant from WELDON Consulting agrees that the trees we are concerned about should be protected as well as the others in the area. We realize these variances are categorized as minor, but they will have an impact on the existing environment in the area. And I thank you all for listening and appreciate your consideration with our concerns.
Okay, thank you, Ms. Hearn. Thank you.
Okay.
Mr. Giordano, would you like to respond to both neighbors' concerns? I know, that drainage obviously is an issue in this area, as we've heard. It's not really part of our approval process of dealing with drainage issues, but perhaps if there are any plans to ameliorate that, if you could let us know. Put the neighbors.
Yes,
If there are none, then just tell us that as well. But just indicate what the procedure is dealing with that through the engineering aspect of the rebuild.
Yes, absolutely. And we have been looking at this very carefully with Daryl and Magdalena, the clients, and we're, of course, as I had suggested at the beginning, we're going to go through a long journey with development services to make sure that the grading plan is developed and approved. I'm not sure if the neighbors understand that it has to go through a very long planned review by development services, and they are going to ensure that the water drainage is contained on our property. Camilla had mentioned that the water drainage that she had concerned about was on the narrow end of the house, but in fact, that's where the side yard is the widest. We have swales along both sides that from the front of the driveway to the back of the house will be controlled. Our water drainage management has to be contained within our property. I know that often adjacent properties have a cross slope to them. This doesn't. We looked at the drainage very carefully. The center line of the street to the front of the house is about a foot, just over a foot lower than the front of the house. So the drainage from the school, from the street shouldn't really be affecting these properties. But of course, as a lot of properties have to deal with, there is reverse slope drainage to the rear of the properties. There isn't cross slope drainage. It's fundamentally, the neighbors on either side of us are effectively higher than our property on both sides, as the existing topographic survey can show you. So we're going to control drainage on our part. I have had discussions with the clients, and we have agreed that we are going to take the paved area that's in the back around the pool, and we're going to convert that all as permeable pavers. We're okay to accept that as a condition of approval. We want to make sure that that's all fine. Addressing Laura's concern at number 7, yeah, we submitted our report from the arborist report early on. It was missed by Angelica posting it on the site. When we were alerted to the fact that it wasn't on the site, we had asked her to post it, and she posted it right away. So we did have it done and submitted well on in the process. It's a very elaborate report. I know that they have a 3-page report. We have a 27-page report that goes through a lot of detail. And I do want to ensure, Laura, that one of the requirements from our arborist is that a certified arborist be on site at the time of the excavation of the pool and the excavation of the house, to ensure that during the excavation, if they uncover any roots that come from the trees on their property, larger than 5 meters can't be pruned. Less than that, with a certified arborist's attention, can be pruned properly. We will do our utmost to ensure that everything is dealt with properly and carefully. Tree number 6 is really the closest to the house. We're just slightly within the tree protection zone of tree number 6. We will also apply for, as the forestry report requests, we will apply for an injury permit for all of those trees. The only part that the house infringes on is really tree number 6.
Okay, thank you. Anyone have any further questions for Mr. Giordano and or the neighbors, or is someone ready for a motion?
Mr. Chair, I find the variances to be in keeping with all tests under the Planning Act. I find the proposed building is very compatible with existing development on the street, especially the immediate neighboring houses at numbers 3 and 7. I move for approval subject to urban forestry conditions 1 and 2, and that the proposed development to be constructed substantially in accordance with the site plan drawings held on file by the Committee of Adjustment.
Thank you, Mr. Taylor. Seconded for Mr. Taylor's motion.
I'll second that with a friendly amendment, if I may. I'll also add the condition of the permeable paving to be used in the pool in the back as a condition.
Okay, that's accepted. Okay, all in favor? Have unanimous approval, Mr. Giordano. Thank you, and thank you, neighbors.
Thank you, committee members. Thank you, Mr. Chair.
Okay. Okay, our next application is item number 10, 30 Wendover Road. This is an application to widen the existing driveway. This matter was deferred from the June 25th, 2020 hearing to consult with urban forestry and the concerned neighbors. We have supporting material and arborist report and photos. We have urban forestry advising that their previous comments and photos still apply, and we have transportation has 3 conditions of approval. But then I think we have a memo saying it's no longer applicable because this driveway widening will not be used as a parking spot, but there are 3 other conditions. Okay, registered as the agent on this is David Eigelman. That's the only speaker we have registered on this application. Mr. Eigelman?
Good morning.
Good morning, sir. I hope I introduced the application appropriately. Can you let us know what's happened since this matter is deferred for consultation with the neighbors and with urban forestry? Bring us up to date.
Yeah, so the application was previously deferred to deal with urban forestry issues. And since the deferral, the property owner retained an arborist to provide the requested documents, which have then satisfied all urban forestry concerns. So they have no concerns anymore with the application. And the documents that we have obtained have been provided to you and should be within the committee package as well. There has also, as you mentioned, been a change to the conditions listed on the transportation report dated March 23rd, 2020. And the changes are to remove condition number 3 as it is not applicable to the proposal that is in front of you today.
Yes. Yeah. Yeah, so I said, so they no longer need that particular condition. You've also provided us supporting materials, including pictures, so we see exactly what the situation is. You're showing us some pictures of other properties, views of driveways at 20 Wendover, 25, and then you're showing us where you are at 30 as well, 33, 38. Okay, committee members, anyone have any questions for the agents?
I actually do have a question.
No, we
Transportation has a condition that it not be used for parking. So I guess my question is, then why pave it over if it's not going to be used for parking? I don't understand that.
So through you, Mr. Chair, the owners of the property would like to use it as a pickup/drop-off area, and it will basically just be used to for temporary use to pick up and as a pickup and drop-off location, and this will also allow it to not block the access to the rear, which is a shared access with the neighboring property at 32 Wendover Road.
Okay. So the neighbor next door, they have any concerns? I don't think there is.
The neighbor at 32 Wendover has no objections to the application, and they actually have provided their signature in support of the application.
Okay, we don't see that. Perhaps it was submitted late? Because I don't see that, but does anyone...
Yes, so the signatures in support have been submitted late, but they are available.
Tell us who those are.
Sorry?
Can you tell us what that is?
What that is? Or who the neighbors are?
Yeah, who are the neighbors who are approving? Is it both adjacent neighbors?
Oh, the neighbors in support are at 38 Wendover Road, 32 Wendover Road, which is the
that's next door.
adjacent
Sure.
property that shares the
Yep.
way access. 33 Wendover Road, and 31 Wendover Road.
Okay, and I see that those pictures show us similar wide. So is it going to be a different material? Like I'm looking at 38, she's given us a driveway. So there's a driveway, and then there's a sort of an interlocked area. So it more looks like a walkway that they could park on, but at least looks like a walkway. Is that the intent, that it's going to be a different material, or what's the intent with the materials?
It's a proposed permeable paver driveway. As far as the what specific type of permeable paver?
Okay, but is it going to look different than the driveway portion, or is it all going to be? It's not going to be asphalt, but is it also going to incorporate? You're going to redo the driveway portion also in the permeable materials or the paving stones, or it's going to be like in some of the pictures where it clearly shows a driveway and a walkway. In this case, it's gonna look like a driveway. You're gonna redo the whole driveway?
I believe it is my understanding currently that the proposed area will be the only area that will change
Okay.
in terms of the material. The proposed pave area will be of a permeable paver material, and the existing asphalt driveway will not be changed. However,
Okay.
those details have not are
So,
not conclusive.
I'm looking right now at the transportation for conditions. Which is the condition, I think, getting at the point Ms. Alderson was making, which is the condition that they're saying is no longer required?
3.
Number 3.
Item number 3.
Okay, so they're saying you're not gonna use it, so you don't have to move the vehicle when the neighbor requires vehicular access to the mutual driveway. So you're not gonna be parking over the mutual driveway. But
Yeah.
you're not gonna be parking a vehicle where it's being widened. Is that what you're saying? But what happens if
No,
you
it
do?
will not be used as a parking spot.
Okay, should
It will
that
be
not
used as
say that somewhere?
Sorry?
I'm just looking at the way it's proceeding, so I'm just wondering if that's something that should be mentioned. Because this talks about if it intends to be used as a parking space, the site plan must be revised. So you're not saying it's not being used for that? Okay.
Yes, it will not be used as a parking space.
Okay. Anyone have any comments, or are we ready for a motion?
I have a further question. I'm just trying to clarify. Your site plan shows a proposed paved area or a hard surface area, but that area does not extend to the sidewalk. Is that correct? To the city sidewalk?
Yes, correct.
So you're just creating a paved area in front of your current stairway?
Yes.
And can we, sorry, I got a little distracted here with some other things going on. What was the defined purpose of this?
That it will be used as a temporary pickup and drop-off area so as to not block the access to the rear, which is the shared access with the neighboring property at 32 Wendover Road.
So in other words, you're going to not park, but perhaps put a vehicle there for drop-off purposes?
Yeah.
So that would mean that you're going to have to drive up the driveway, and I don't know how you cover, like, you can't make a 90-degree turn with a vehicle. So I'm a little confused. You're not going to be driving over is there going to be a garden area in the front, or is that going to be a landscaped area that will wind up getting tire tracks on it?
Yeah, and also, I just found something while Mr. Kamerick was asking you that question. It says here in a memo that, it's not going to be used for parking, so that condition 3 doesn't apply, but they do say, and I'm asking if this has been done, or should be done, the attached revised plan dated July 14, 2020 shall include a notation indicating that your driveway widening will not be used for parking purposes. Has that been done? Or if not, we'll
That has
we'd
not
have to
yet
impose
been
that
done,
as a condition.
but it is an acceptable condition.
Okay, has there been a notation on the site plan, on the revised plan?
No, that has not been done yet, but again, that is an acceptable condition.
Okay, you're okay with that then? As stated
Yeah.
in his November 16th email. So that would have to be a condition, an extra condition, to add a notation to the site plan or to the drawing. I guess it is a site
Correct.
plan. Okay,
And,
any more questions?
Just to go back to that, the previous question, I was having a little trouble understanding what the question was exactly.
Well, I guess where I'm going is that you're essentially widening the driveway for the purpose of parking a vehicle on a short-term basis. I guess in terms of traffic law, you would call it stopping rather than parking. And to do that, you would need a surface area that's going to be conducive to you turning into it. And to me, I mean, you're widening the, anyway, it's.
Just to address it, it is my understanding, first off, that transportation has no objection subject to their conditions with this application. And I believe the proposal would be satisfactory in terms of being able to pull into it and stop.
Laura, are you on mute? Laura, can you mute yourself?
No, I just wanted to ask a question.
Okay, go ahead.
It's a question of staff, actually. I mean, it's all very well and good to have this parking spot there for pickups and drop-offs technically, but how is that monitored? I mean, how can that be monitored? If the transportation doesn't want to use it for parking, I mean, really, I just don't understand how it's going to be monitored.
Anyway, the point is, when I'm looking at the pictures that the agent has provided us of other situations on the street, is that very similar? It's not similar.
Yeah.
In my view, the
They
pictures of
would
the
be
other.
similar.
Okay, go ahead. It's okay.
You're saying it is a similar situation? How so? Just, you've given us pictures of these other properties on Wendover.
Well, it will be similar in that it will be a widened driveway that those other properties are exhibiting and have as an existing condition. And the proposed permeable pavers, I mean, I can't speak to what they will look like because those details I'm not aware of yet, but it will be similar in that it will be a widened driveway that will be of similar length and width to those other houses in the neighborhood which have it as an existing.
Are you going to have to get, what about the curb cut? Is there going to be an extended curb cut?
No, there's no curb cut.
There's no curb cut. Okay. Okay, anyway, I think we've spent, anyone has any follow-up
I
questions?
have one final comment, and I believe the photographs that have been shown as comparable are situations where people have indicated pedestrian walkways adjacent to driveways, and that's why you have that's why you have a differentiation in the paving surface. And those extend all the way to the public sidewalk. What is being proposed here does not extend to the public sidewalk and is therefore not the same. And those may be used for something like that, but then the width there is probably less than what is a full car length. What is being proposed is a full car length that does not extend to the sidewalk. It's not the same thing, and therefore, this argument to me is nonsense.
Okay. Someone ready to make a motion? Yeah, so the difference is it doesn't go to the sidewalk. Be some confusion because maybe people are not going to park there and thinking that.
Through you, Mr. Chair, I will also note that planning has had no objections to the application as well.
Mm-hmm. Yeah, we know. We see there is no planning memo. We have urban forestry, their previous comments still apply. And we have the conditions, which you said you're fine with, as well as to make that notation on the site plan. Just confirm, summarizing what you said. You're okay with the transportation conditions. You're okay with making that notation as a further condition that it's not to be used for parking. And we have urban forestry that their comments still apply. Okay, so are we going to bring this into committee? We'd like to make one final comment and we're going to bring it into committee.
I just wanted to note that urban forestry, their conditions and their report does not apply anymore due to the arborist report that we have submitted.
Okay, and have they signed off on that, or? I thought I saw something where it said that they advised that their previous comments still apply. I had a note to that effect. Can't tell you where it is right now, but I do have that note unless I'm wrong.
Yes, I believe that note is from prior to the arborist report being submitted. So there is correspondence.
I will tell you on these deferred hearings, it is rather confusing to us, and the committee members agree with me, in that we get all the materials for the previous date, including letters, many letters that may or may not be applicable because they were referring, and some of them aren't even dated, so you can't even tell if they were from the previous date or not, if they're dated before or after, in this case, June 25th. So it gets a little confusing when you're looking at things and what it is. So is someone ready to make a motion? We're taking it into committee now, sir, so unless you're asked a question, you should be muted and not be making further submissions.
Mr. Chair, I don't see this proposal as being reasonable development for this area. I'm anticipating human behavior, and I can imagine the homeowner pulling into this space, delivering groceries or people and leaving the car there because it's convenient for them. And given the fact that there's a mutual driveway, it's convenient for the neighbor. So I think ostensibly, notwithstanding the condition that, the notation that transportation is asked be placed on it, I share Ms. Alderson's point of view about the enforceability of that. And I just can't encourage front yard parking on this street.
Yeah.
And I think that's what's going to end up happening here. So I don't think it's reasonable or appropriate, and I recommend refusal.
Okay, thank you, Mr. Taylor. Do we have a seconder for that motion? Mr. Kamerick and Ms. Alderson, so I guess it's unanimous. The application is refused. I just point out, just seeing a letter from Pat Tremaine, one of the neighbors. She's saying that there's been 3 other properties that requested to widen driveways to accommodate side-by-side car parking, and they've been denied. You know, and it says will certainly be used as a parking. I agree with Mr. Taylor. It looks like it's going to be used. It can be used, and there's no enforcement. So thank you. I'm sorry about that, sir, but the application has been refused. And we'll move on to item number 11, which is our next application. 18 KENTROYAL Drive. It's a detached dwelling with an attached garage, 7 variances. Planning has 2 conditions of approval. And this matter was again deferred from July 30th, 2020 hearing to correctly identify the variances. Okay. And the speaker on this application, we only have one, is Tanya Pajovic, the agent.
Good morning.
Good morning. Can you just
May
give us
I,
your name and
present-
address, state it formally for the record, please?
Yes, of course. Good morning, Mr. Chairman and members of the committee. My name is Tatiana Pejovic, and I'm the agent for the owner of the property at 18 KENTROYAL Drive, and my address is 42 Denver Crescent, Toronto.
Okay, and I see we do have a letter of concern from 16, concern with the grading, which is really not something. You're aware of the planning conditions, ma'am?
Yes. In fact, our application was deferred on the hearing on July 30th due to initially issued zoning notice in which was missing 1 variance. In the updating zoning notice, which was issued on July 13th, this issue was corrected and the list of variances completed.
Yeah.
We see that the updated staff report was uploaded on October 17th, and there are indicated 2 conditions in respect to side yard setbacks, which was also previously in the previous staff report, and it is added floor space index as a condition. I would say that we agree with conditions that the building is substantially constructed in accordance with the site plan and the site setbacks which are shown on the site plan. And also in communication and talks with my client, we agreed to reduce floor space index, but we believe that it can be matched with the floor space index, which is at the house 20 KENTROYAL Drive, and which is 0.59. This floor space index was approved on February 2017. And we hope that it can be also accepted for our proposal.
Yeah, okay, because a little strange, they said that they wanted the variance to be less than 0.6. You know, does that mean
Yes,
0.599999? Like, I don't understand, you know, that's a little odd. They should have said 0.59 or, you know. So you're obviously, then you have to reduce it slightly. They just, I guess, don't want that number to show up for precedential reasons, I guess, for issues of precedent. So what have you done in response to that? Because how do we tie it to your plan? Oh, it says relating to only the side north setbacks. Okay, I was going to say you're going to have to take off a very small something. So how do we tie it to the plan? But they only want the site plan relating to the side yard setbacks. So you're okay with that?
So we are okay with this condition that it is tied to a side yard setbacks, and we were thinking that reduction of floor space index would be just shortening the length of a house for 1 foot. That will give us floor space index of exactly 0.59. So the side yard setbacks will, where I believe the planning report has concern, and that is that along the certain length, we have a 0.2 meters.
Okay, so I just want to make sure you don't get into trouble if they say, well, it's tied to the site plan, but the site plan's different because you're taking a foot off the back, or I don't think that would be a problem, Madam Secretary Treasurer.
I hope it won't, because generally we will keep all area where I believe that the staff members have a issue, and that is in fact 4 feet distance from the side property line. So that area will remain as is, and we will just in fact shorten the house 1 foot, and we believe we will achieve this 0.59.
Okay, so do you know how many, you have to say it in meters squares. Do you know how many meters squared is 0.59 is, or anything under? 302.2 meters squared is what you propose, so it has to be, we're changing it, the approval of revising item number 1, variance 1 to 0.59, we need to know how many meters squared that is.
Let me just check for a moment.
Okay.
So it would be it would be 296 square meters.
Even. So that's from 302.2 to 296.
Yes, or 295.91, but it is.
Let's say 2.96. How's that? Okay, committee members,
Yes.
any further questions for the agent, Ms. Pejovic, or are we ready for a motion?
With the revision, I do suggest that you not tie it to the plan, just to avoid problems.
Yeah, that's what I was anticipating. Well, they want it only for the north and side setbacks. So that will not change. I think they, there is perhaps a reason to have that attached.
If there is possibility, maybe not to tie to a plan, so of course, just to avoid the possible misunderstanding, we would like this option as well, especially if there is concern about the setbacks. House number 20, KENTROYAL, has all along setbacks which are 3 feet on one and the other side. This proposal at
we don't want you to have a problem that the conditions conflict with one another, and that you have a problem down the road.
I mean, there is a variance for side yard setback on both north and south side lot lines, and for the most part, the dwelling is in line. There are two small jut
Yeah,
ends.
juts, yeah.
But if
dug
they
in.
were to bump those out, their floor space
Yeah.
index would go
Yeah,
up.
so there's the
I don't
protection.
think they can make any more changes.
Okay. Okay, so someone want to make a motion?
Okay, I'm going to give a crack at it. I'd like to move approvals, seeing that believe it does meet the 4 tests. And I think we'll try to do this without conditions, but with a amended variance 1 to 0.59.
296 square meters, right?
And whatever the meters, because I didn't write it down, sorry.
Right, okay. And,
Also, an urban forestry condition number 3,
correct.
Thank you,
I
Ms.
believe.
Yes.
Okay, so I'll take that as a, you seconding the motion with that friendly amendment. All in favor?
Yes.
Unanimous approval. Okay, thank you, Ms. Pejovic.
Thank you very much for the approval.
Okay. Our next application are items 12A and B. Address is 21 Old Oak Drive. And is there another address?
No, Mr. Chair, the agent isn't here.
The agent isn't here.
I've sent an email to staff, but they haven't bothered to respond. So I think this application these two applications have to be deferred. I believe that they obtained further revised zoning reviews, so the information before you is not correct.
Oh, okay.
Even though that was the reason for their last deferral. But I don't know the circumstances because I haven't been advised.
Okay. So the agent is not here. We don't have anyone else registered to speak on these two matters, or A, B, A, and B. It was subject to urban forestry. There was a previous decision in order to comply. So is this I'm just wondering if the delay is going to be it's to legalize and maintain existing detached dwellings, so they overbuilt, exactly. So
And
the fact
community
that
planning
what if
wants
they
it
keep on showing
refused.
up to hearing? What happens to the fact that, typically people are coming here, and when it gets deferred, it's at their peril because they're delayed in what they want to do. Right. And there is.
And community planning wants it refused.
Yes. So, if the agent just doesn't show up, isn't that a good thing? He doesn't get his refusal, and life goes on. Right. But I'm saying if there's an order to comply and it's an offending situation, we have to make it maybe preemptory to him next time it's up, or if you just leave it to him to reschedule it, he just will never reschedule it. Right? So in a situation like this, do we not have to make it?
I've tried to get information from both staff and the applicant. It's not clear to me whether staff made the mistake or if the applicant neglected to submit the revised zoning review. I'm not entirely sure, so I don't want it to.
Right. So this matter was deferred in order to obtain a zoning review and to carefully identify the variances. So, if it's already been put off from August 27th and now we're November the 24th, and then it comes back. So meantime, this matter is just not getting dealt with. So I don't know if there's, anyone being affected by this, by letting this thing just sort of go on and on. They did provide us with, planning justifications, and so is this a stall tactic?
I honestly don't know because.
Okay, I just
no
point
one
that
has
out.
Responded to me.
Okay, I just point that out. Given that he has a refusal, and given this is already built, then it's smart just not to don't show up to the hearing or don't reschedule it. So.
But I'm not clear whether we made the mistake or if the applicant did,
Okay,
and I
so
don't
perhaps we
want
can look
to
into that.
penalize them if,
Okay.
if they're.
Okay, because can I have a motion to defer, I guess, on both 12A and B?
I'm happy to make that motion to defer.
Okay, but Mr. Commander, what if is the agent just not here? I was going to think we hold it to the end of the time slot, or they're just not here? Okay, so perhaps with just some verbiage that this has got to be, if this staff should investigate to see what is occurring here, and if this is a stall tactic because it's a order to comply as built situation.
You can you can give us, in the past, you can, in your motion, include a deadline to submit everything so that we schedule it within a reasonable amount of time.
Yeah.
once it's been
Question of staff,
What do
staff,
you
what
suggest?
would be an appropriate deadline?
Yeah, same thing.
You can say that by a certain day, whether it's December 10th, that's a random day I'm picking out.
I know, but we're looking to you for guidance as to what, December 10th is not a long time from now. Is that reasonable, or a month, or, and then what happens if they don't? Does the file get closed, or it's just rescheduled? We need to,
So what we did in the past, the one I'm thinking of, we gave a deadline where the applicant had to submit revised materials. If the materials were not submitted, the files would be deemed closed.
okay, because it looks like last time maybe there was some confusion about what the variances were.
Yes. And they
But-
did obtain a zoning review, but I don't know, I think there was an issue with the zoning review that was submitted.
Okay, but if you read the planning memo, planning has concerns it was built, not constructed in compliance with the approvals. Therefore, they need minor variance to legalize and maintain what's been built. And planning staff is saying it should be refused, and it's not in keeping with the prevailing character. These after the fact proposed variances. So this matter, perhaps for legitimate means, got deferred in August, and now we're in late November, and they just didn't show up. I think we need to bring this to a head. So you suggest December the 10th? Okay. And failing which, it will get scheduled. Oh, it'll be deemed closed. Okay. Laura, is that your motion?
So yes, so the motion is to defer, giving the applicant an opportunity to submit all documentation by December 10th,
31st, we said.
By the
December 31st?
Sure.
Okay, so that's my motion, by December 31st.
Okay. Thank you. Second.
Failing that, the files would be deemed closed.
Well, hold on. If the
Failing that,
file's
the file
closed,
would be
there,
deemed closed.
this is an as-built beyond.
Then they have to reapply.
Okay, so their penalty will be
Because
a
if
second
a
fee,
file
but-
stays open, then there's no way to pursue enforcement.
Right, but if they.
But so if the file gets closed, then MLS or Toronto Building Inspections can pursue
And
whatever
they will be
violations
so
they have.
advised that the file has been closed in light of the order
they
to
have no remedy
overbuilding. Okay.
And that's a financial penalty for that, because they have to refile.
Well, we're not considered a penal body. However, we would be closing the file because it's been open since August. It got deferred, and they're not here. So it's in their
They'd
benefits.
have to refile.
As opposed to something that's not built, it's at their loss. In this case, it's at their benefit because they just keep living in there or using it, and planning staff is saying it's inappropriate and should be removed. So, okay, thank you. So we have a seconder for that, just for
Sure, I'll second that.
Mr. Kamarick, all in favor? Okay, we got the deferral in that. Okay, item number 13 is the next application, which is 49 Mitcham Drive. It's an application for a two-story rear addition, rear yard deck, and a detached garage. There's 7 variances. There were 12. This matter was deferred from the September 15, 2020 hearing to consult with transportation, and I guess they've made some changes. There's a cover letter which outlines some further changes to the variance, and the second letter as well regarding the side lot line for the detached garage. And planning is looking for a condition of approval that it be built substantially in accordance with the site plan dated October the 16th. And that's all we have. The speaker on this application are Michaela Silva, the agent, and Sina Golkar from 38 Valentine Drive.
Hi, good morning, Mr. Chair. My name is Michaela Silva, and I am the designer and applicant for this address.
Okay. Can you
Uh,
just briefly advise us what's transpired? Sort of, you made some
Yeah, of course.
changes?
Yes, we've made a significant design changes to our proposal, just so that we're more in keeping with the zoning bylaw and the four tests of the OP. We were previously asking for 12 variances, as you've mentioned, and now we've reduced those to 7 and improved 3 variances. So in summary, we have increased the south side yard setback variance of 0.47 meters to 0.9 meters. We've reduced the floor space index variance of 0.473 to 0.469, reduced the lot coverage variance of 39% to 38.5%. We've removed the southeast side yard setback variance, removed the soffit height variance. Now for the garage, we have removed the rear yard setback variance, removed the east eaves side yard setback variance, and removed the height variance for the garage.
And
Yeah,
that's
those are
all
the
succinct.
changes.
That's all set out in your letter dated October the 3rd.
Yes.
Thanks.
Yes,
It's
that's
very
correct.
helpful.
Yes. Yeah. And planning has reviewed the revised plans. They've outlined in their letter that they have no objection, although they did say that they would like to make a condition for the site plan that we've submitted to be as a conditional of approval, which we're okay with that. We've also dealt with transportation recommendations, so they have no further issues as well. Yeah, no conditions. And we have also letters of support from 13 neighbors, both from Radlett Avenue and Mitcham Drive.
Okay, thank you for that summary.
No problem.
We do have a neighbor here, Sina Golkar of 38 Valentine Drive.
Hello.
Hello.
Hello, Mr. Chair. Hello, members of the committee.
Yes, you're the owner of, it looks like I have a letter here, I guess dated before the first time from September hearing time, that you're the owner of 47 Radlett Avenue?
Correct, I am.
Okay.
Okay.
So we have
my
your
property-
email, your original email in September, and then we have another email from you dated November the 15th.
Correct, yes.
Okay, so you say that these variances will greatly affect the desirability of view and access to light, increase the risk of falling ice and snow into my property, and against the law. They are simply unfair. Okay, so you're requesting that we deny the variances. That's what you have.
Correct.
So can you
I
please,
am.
can you please just expand on that? Tell us how this application affects you negatively.
Okay, so the most important item that is affecting my property is the lot coverage. This is substantial increase in the lot coverage from 33% to 38.5%, 5.5% lot coverage, bringing the property way more east or covering the backyard, their backyard, and therefore blocking my backyard. That's the first thing. The second thing is that the house that is there now, is a bungalow. It's a single story, and adding this 2 stories is gonna make it a very odd looking with a lot coverage, but not a lot of height in the existing part, and higher elevation in the addition. And the elevation also is going up to 1 meter above what is allowed normally. So all these together, this is substantial. I don't understand how, at the expense of someone else, this can be allowed to be done for another neighbor.
Sir, where's your house in relation to the property?
South of there. We are south of that address.
I see. Okay, I don't know if you've read the planning memo. In terms of you talking about the lot coverage, you agree it's 38.5 compared to 33. The planning memo notes, sir, that the increased lot coverage is due in part to the proposed rear deck and wraparound porch, which accounts for 8.1% of the proposed lot coverage of 38.5. So they're saying without that, it would be approximately 30.4, which is compliant with the lot coverage. So they're pointing out that their only concern, they want us to be built, make sure they build what they show on their plan, but they don't feel that the coverage is excessive. Is your house a bungalow, sir, or you have a two-story house?
It is. It's a bungalow.
Okay.
It's a small bungalow, and by doing this, as I said, it's not the only reason. The existing part of the structure that they have there, is a small bungalow, and it looks like it's an older house. Looks like a cottage, and by adding a two-story extension to it, I guess that's not going to be my right to say that, but it's not going to look anything beautiful because again, it's one piece is old, one story, and the other piece is going to be two-story, very high. The height of it is going to go 1 meter above what is allowed normally, and it's going to come closer to my property also.
Yeah.
So all of that considered, it's going to be a high structure right beside me and closed. So it's imposing, and anything falls from that height, 11 meters, is going to be really dangerous falling into my property, being so close to the property line altogether. I don't think it's reasonable, but I was listening to all the cases before this and the other day. None of them were anywhere close to this. So, yeah.
Sir, are there any other two-story houses in the street?
Yes, I'm sure they are not immediately close to me. The one after, I don't think so either. But yeah, there are. Of course, there are.
Yeah.
There are the two-story houses in the neighborhood. Yes. Yeah.
Okay. Okay, anyone have any questions for Mr. Golkar before we go back to Ms. Silva to respond to those concerns? Okay, Ms. Silva?
Oh, yes.
Okay, can you please respond to the neighbors' concerns?
Yes, of
And I'm
course.
just trying to see. So just before we do that, can you just have the neighbor? What's the address? It's because he lives at 38. I think I
His
just
address
read it
is
out.
47 Radlett Avenue.
Okay.
So he's situated south of
Immediately south.
our lot.
Yeah.
Yep.
Immediately south, yes,
Mhm.
that's correct. Yeah.
Yes. Okay.
Yes. So there are a few houses in the neighborhood with 2 stories also. And this height variance that we're proposing, I mean, it is a 1 meter over what's allowed, but I don't think it will be a significant issue in terms of light because, well, the light issue cast by our proposal to his 1-story dwelling is, I believe it's very minimal, even with this height variance. His house is situated, like I said, on the south side of 49 Mitcham, and the sunset trajectory runs east to west. So he will continue to receive most of the sunlight that is available. And further to that, his house is 3.2 meters away from the common side yard setback, plus another 0.9 meters to our proposed rear extension. So there is a total separation of 4.1 meters. That's over 11 feet from our house to his. So, the light issue is potentially none due to the existing location of his house. If he was way closer to us, I'd say maybe 1.4 meters, maybe that would be the case. But in this case, I don't see it being an issue at all.
Okay, thank you. Anyone have any questions for the agent or for the neighbor for that matter, or are we ready for it?
I have a question for staff. I just wanted to clarify the legality or what's being proposed here is 2 driveways. One which will be a parking pad to neither the rear of the property nor to a garage. It's just a parking pad in front of the house, even though there will be a garage with a proper driveway. I'm assuming that this has gone through all, has been properly vetted, and this isn't something that's been overlooked, because I know in some areas of the city that would not be allowed. Is that something that is allowed in this part of the city?
Not as far as I'm aware, but they've submitted with a waiver.
Oh,
So-
they submitted with a waiver.
Okay, so potentially, there could be another variance required for this second driveway?
Yeah, usually a driveway has to lead to a legal parking space, and you also aren't permitted a driveway in a front yard.
And that's what's being created here, so that's my concern.
Yeah, but there aren't variances that identify that.
Yeah, we did do, Mr. Chair, we did do a zoning review prior to the waiver being submitted, and there were no variances relating to this parking pad in the front of the house. So we can confirm that there are no variances specifically for that, but we are aware that if they do come up in the future, that it's something that we would have to come back to committee.
And this was reviewed by transportation as well, because they would have to be approving to a curb cut here, no?
Yes. That's correct. And even transportation asked me to add some annotations in regards to the hedge that is currently in the front of the house. If you look at the site plan, yeah, page A1, it's in bubbled. There's an annotation there, bubbled, saying that the existing fence is to be trimmed down and maintained at a maximum height of 0.85 meters. So this was something that transportation asked us to include into our site plan.
No, I see that. There's also a
Yeah.
notation about closing redundant curb cuts, so. Okay,
Okay.
this kind of surprised me, so I'm.
Okay, good catch. There may be a further, then they'll just have to come back and pay another fee and wait for another hearing if they missed something and this is a waiver. I recommend we deal with what's before us and go from there. So is someone ready to make a motion?
Mr. Chair, I find the requested variances to be extremely minor in nature, and that they meet the other tests under the Planning Act as well. So I would move for approval, subject to the condition of the Planning Department.
Thank you, Mr. Taylor. Seconder for that motion. Ms. Alderson, all in favor? Okay, you have unanimous approval. Thank you, Ms. Silva.
Thank you,
Thank
members.
you, thank you,
Thank you.
neighbor. Okay, our next application is item number 14, 0 Skeens Lane. This is an application that was deferred from the October 6th, 2020 hearing. It's to permit 9 visitor parking spaces that will serve the adjacent property municipally known as 3418 Lakeshore Boulevard West. The variance is that a parking space shall be provided on the same lot as the said building, and the proposed 9 visitor spaces will be used as supplemental parking for the adjacent condominium located at 3418 Lakeshore Boulevard West. And we have a planning memo dated September 29th, advising that we should defer this or refuse. Transportation has conditions of approval. Urban Forestry is looking for a denial. And basically, we have objections, 12 letters of objection. And we have, most importantly, planning is still saying that this matter should still be deferred or refused. They go into the history of the matter in a planning memo. So registered to speak on this matter is Glenn Wellings, the agent, as well as...
Hi, good afternoon, Mr. Chairman.
Okay, and as well, just to say, we also have residents from 9 Skeens Lane, Unit 1, 8 Skeens Lane, Unit 4, and another speaker from 3450 Lakeshore Boulevard West. So, Mr. Wellings, let's start off. You've read the planning memo?
Thank you, Mr. I sure have.
Okay.
Thank you, Mr. Chairman, committee members, for hearing me. Good afternoon. For the record, my name is Glenn Wellings. I'm the planning consultant for the applicant Eden Oak. And just to explain a bit about the application, Eden Oak owns the subject lands with the municipal address of 0 Skeens Lane. Eden Oak also owns the adjacent property at 3418 Lakeshore Boulevard West. And on that property is a proposed 5-story, 30-unit mixed-use condominium building. The purpose of the minor variance is to provide supplemental parking on the 0 Skeens Lane parcel of land. The site plan and the previous minor variance for the condominium was approved with a parking reduction on the understanding that this matter would be brought forward to committee regarding supplementary parking. So this should not be a surprise, Mr. Chairman, this application to city planning staff. The city has insisted on ground floor commercial for the mixed-use building. And that is one of the significant reasons behind this application. To explain, the residential parking has been eliminated on the ground floor to provide for this commercial floor space. And the commercial floor space in itself has generated its own parking requirements. So it's really a double whammy here based on the requirement for ground floor commercial. So the response to the minor variance application has been a bit surprising, given that these lands are presently being used for parking. And the committee should note that the north side of Skeens Lane already consists of parking. And there is some new parking that's also being proposed. And this parking that's existing now is often used by the Skeens Lane residents because the condominium apartment building does not exist at this point. So staff's interpretation that the supplementary parking requires an official plan amendment is to me a little bit surprising. I've not been provided or cited with any official plan policy that is being offended by this application. I've repeatedly asked city planning staff for that clarification, and they have not provided a policy which is being offended by this application. With respect to the concerns of the Skeens Lane residents, I think, Mr. Chairman and committee members, you're damned if you do and you're damned if you don't. Without this supplementary parking, I'm pretty certain the residents would be the first to complain about the overflow parking of cars on Skeens Lane. So this application is trying to avoid such a situation. In my experience, residents typically want to maximize rather than minimize parking availability, and that's the purpose behind this application. And Mr. Chairman, just in closing, it would be helpful if the residents could confirm whether they have concerns with the existing parking that's on Skeens Lane now. And I think that would be helpful moving forward, and I'm certainly happy to answer any questions of committee. Thanks for your time.
Thank you. Just reading the covering letter. So the LPAT decision reduced the reduction of parking from 30 to 24, and
correct,
for commercial uses from 3 to 0.
Correct.
So did that not? So you still need these 9 spots?
There's concern. For the 30 units, yeah, we do need these additional spots, okay, and plus the commercial. Yeah, so there's a concern, Mr. Chairman, about
so out
not
of
having
how many
sufficient
spots?
parking.
Okay, you want to give 9 spots on this 0 scheme. How many parking spots? So does that mean there are another 15 that are on site for a total of 24?
No, there's 24 on site, sir. So these would be so right now the variance is not asking for a parking reduction for the lakeshore property. It's asking for supplementary parking on the Skeens Lane parcel, which is owned by Eden Oak.
Okay,
so it's
these 9
supplementary
spots,
parking.
Right. So these 9 spots are not to satisfy any zoning requirement for parking. They are additional spots being.
That's correct, sir.
Okay.
Correct.
So the question is, why does planning tell us that, as they did in October, that this matter should still be deferred until site plan, or it should be refused?
I think, Mr. Chairman, that's a good question for your planning staff.
I thought so. Yeah, it says it'll be used for
I
supplemental
have a note
parking.
here. I have a note here that community planning is recommending that it be deferred until an OP amendment application is submitted.
Yeah, we were aware. That's why I'm asking why it should still be deferred until the OP, and I'm asking that of the agent.
Yeah, Mr. Chairman, we're not coming forward.
Why can we not do what planning is asking?
We do not believe an official plan amendment is required. And that's why, Mr. Chairman, we cited our dialogue with city planning staff. We've asked for confirmation of the policy that's being offended that would trigger an official plan amendment. We have not been provided with that.
Okay.
So currently on Zero Skeens Lane, on Google Earth, I'm seeing 5 parking spots. Is that correct?
Yeah, that's correct, sir.
Okay. And you're essentially going to recreate those and then add some more on the other side, on the west side.
That's correct, sir.
Yeah, so it says here, planning staff noted. It says, city staff in strategic initiatives, policy and analysis, and legal services consistently advise an OPA application would be required in order to consider providing parking spaces on Zero Skeens Lane. Planning report also clearly states in order to consider any potential parking space on Zero Skeens Lane, an official plan amendment will be required in order to designate the lands as mixed-use area or to introduce a site and area-specific policy to allow the uses associated with the mixed-use development area. Staff continues to be of opinion OPA is necessary to support the OP goal of protecting and enhancing existing neighborhoods while encouraging growth in targeted areas. Again, they said they've communicated that to the applicant, and that they've advised that a minor variance application is not the appropriate process to move forward with the current proposal, and that without an accompanying OPA application, the current or minor variance application remains premature. So, like, we're being told by staff and by strategic planning and by city legal services that that's what you have to do, and you disagree, but
yeah, I do,
sort of in the
Mr.
middle of
Chairman.
this, right?
Yeah, Mr. Chair.
Yeah, Mr. Taylor has a comment.
Sure.
If I may, the planning report also includes a paragraph that reads, the neighborhood's policies, and this land is designated neighborhoods, do not provide for uses accessory to the mixed use areas, such as parking spaces, to be accommodated on abutting neighborhoods designated lands. As a result, the proposal requires the submission of a related OPA application. So that's the rationale.
And
the proposed use does, sorry, sir. The essence of this is that your proposal does not conform to the official plan, and one of the 4 considerations we must take as a committee is compliance with the official plan. So that's really the crux of the matter. And they have stated their rationale.
So my question, Mr. Chairman, to the committee member is, show me the policy where it says that. Give me a policy number where it says that. And I've not been satisfied
They're articulated.
with that,
They are articulated ad nauseum above the paragraph that I just read in their report.
Show me the policy where
Well, I
it
can't
says that.
show you. I'll reference it. It's the report dated September 29th, 2020.
Anyway, sir, we're being told by various city departments, including city legal and planning, that this application, they've explained, you're saying, well, show me where it says that, but they're saying that. They also, I think what's behind this is they're saying, originally when you got the parking reduction, that the applicant's planner supported that, and now you're coming back for additional parking on another piece of property that, okay, you still own, but it's a separate piece of property. It may not be owned in the future. It may be owned by 2 separate condominium corps. So I think we're trying to be very polite to you, but by having this in front of us, I don't see how we can proceed to grant you your application, given on what we're being told here. So the question is either a deferral or a refusal, and you can take it to LPAT if you get your refusal, and flesh it out, or you want one more deferral to, but I don't see why that helps you, because they're saying you need an OPA for this. So committee
Can
members,
I add,
yes, Laura.
can I add something too?
Yes.
Urban forestry is also not, aren't they requesting a refusal?
Yeah, they're doing, yes, they are. So that's one more factor. That's,
So it's not just planning, it's urban forestry as well.
well, the forestry may not be as big an issue as the actual.
No, no, it isn't, but it's an added.
Okay. Yep. Okay, so can someone ready to bring a motion?
I just wanted to make one.
Mr. Chairman, do we not hear from the residents?
Oh, sorry, there are residents on this.
Yeah.
I'm sorry about that. Yes, we have 3 residents speaking. First one is Dan Burr. I don't know if the H is silent.
Berhe.
Good afternoon, sir. Can you let us know what your concerns are? You reside, and just explain where 9 Skeens Lane, and you live in one of the units there? Or is that an industrial unit or
Yes.
residential?
Yeah,
It also says that Alan Roy is representing the street, the other speaker.
Yeah, should I continue?
Yes.
This is Daniel. Okay, good afternoon, and thank you for the opportunity to speak in front of this
Can you
committee.
please speak a little
My name is
clearer and
Daniel
louder,
Berhe.
sir? Sir, can you please project into the phone a little better? Your voice is trailing off.
Okay, is this better?
Yes.
Okay. Good afternoon, and thank you for the opportunity to speak in front of this committee. My name is Daniel Berhe. I'm the property owner of 9 Skeens Lane, Unit 1. I'm also a father of 4, with the youngest being a 3-year-old daughter. The reason I love Skeens Lane is because it is a quiet and secluded street from the hustle and bustle of Lakeshore Boulevard. I fully share, which you will get to hear, I guess, soon. I would fully share and agree with the concerns raised by the Skeens Lane Owners Association and other Skeens Lane property owners. I'm here today to object specifically the proposed 4 new parking spots on the east side of Skeens Lane because they are adjacent to my property. My objection to the new 4 parking spaces are centered around these points for your consideration. First is security. Now, complete strangers coming in and out of these parking spaces at all hours, where our backyard gate is next to these proposed parking spaces. Second is privacy. Anyone standing in these parking spaces has a clear view of our backyard where my daughter could be playing. The third one is safety. My daughter rides her bike and walks and runs around Skeens Lane with minimal supervision because it is a private street with very little traffic. Now, with visitors driving in and backing out of these parking spaces, I worry for the safety of my daughter. In a nutshell, I guess I asked for this committee to take a careful consideration of my concerns and the concerns of other property owners and reject the variance to add this additional visitor parking spaces on Skeens Lane. Thank you for your time.
Thank you, Mr. Bear. Mr. Roy of 8 Skeens Lane, it says you're representing the street, so please tell us something about that.
Chair, committee members, thank you for your time today and allowing me to speak. My name is Alan Roy. I live at 8 Skeens Lane, unit number 4, and I'm speaking on behalf of the 29 residential units of Skeens Lane. A couple of the local businesses on Lakeshore Boulevard West, and I believe for at least 1 household each on 29th and 30th Streets. And I spoke this morning with the Salvation Army chaplain, and she has given me right to speak on their behalf as well.
Okay.
Is it worth my going into my entire presentation if you are willing to put it to a vote? I'd like to save us all some time, and I'm cognizant of the fact that you guys are running late. It's my pleasure to be here, but I'd also defer it if need be.
One question is whether you have the right to tell us, make your presentation. I don't, you've seen the letter from planning and you've heard what's gone so far. So, but why don't you let us know what the concerns of the neighbors are, in addition to what Mr. Bear has told us?
Certainly, all
Since
right.
you're representing the other people, you feel these spots are not appropriate to be used for parking.
No, not at all.
Yeah.
I just,
That's why
while I may,
that's an impact to you and the other neighbors.
While I may, I'd like to clarify that it's not the west side of Skeens Lane running north-south. It's the east side of Skeens Lane running north-south that is projected to be developed. So it's beside or adjacent to 9-1 and nearer to 29th Street, not away from.
Okay.
That was mentioned earlier. Okay. As I say, the number of people I'm representing is to allow for us to be aware of the committee's timings, and
Yes.
It was determined that rather than have all 29 of
Yes.
the residents speak, we would prefer that you guys not have to endure that.
Yeah, especially in the virtual world, when people attend in person, they go outside the room. If there's 15 people or 20 people and they appoint a couple of people who are going to speak and they don't all speak. But in the virtual world, we don't have that opportunity. We also don't have an opportunity when matters are being held, contested items, for the parties to go out and try to negotiate something in the hallway or have a discussion at least. So we are what we are. So
Granted.
I appreciate that you've been appointed the spokesperson. Just in a few minutes, just tell us, in your words, how it's inappropriate. All these 9 spaces be used for the other adjacent property and the impact on the neighbors.
Since I'm the representative for all 29 units plus, I figure I've got somewhere around 2.5 hours to present to you.
Well, you got another
let's
two.
not go that way.
You got another
Let's
2
not
minutes
go
and
that
30
way.
seconds left. The Coles Notes
So,
version.
There you are. Thank you. Paperback is everything. I'm much better in person, by the way. I'm representing many who are too shy or feel that their language skills may not serve them well enough to present their views. I'm privileged to be representing all of my neighbors, and that's grand. I don't want to belabor the numerous reasons.
Yeah,
that
we
you
have all the
already had
letters.
in
We do
front of
have
you.
all the letters.
Exactly.
12 letters.
And that's what I'm referencing. Rather than me repeat all of the letters points, that's not part of it.
Okay.
I'm an original owner. Yes.
Okay.
I'm an original owner. I'm one of the 10 remaining on the street, and I'm across from the proposed parking pad that they had previously built and then subsequently dug up because of complaints from the neighbors who had been residing on 29th Street, and for the same reasons that they're now objecting to this development anyway. We've got nothing but problems with cross traffic that's going through our street. We don't require any more of that happening. Yeah. And any parking that goes on at the south end of our street is bound to lead to more traffic on our street. Yeah. We're a private road. We look after all of our own requirements on the street, including snow removal, and we have to pay liability insurance. We've installed speed bumps to reduce the amount of access to our street. And we're trying to minimize parking, not maximize parking in the neighborhood, as was mentioned by the representative for Eden Oaks. We don't need extra parking. The 5 spaces that are on the east-west portion of Skeens Lane on the north side, they exist now. Rather than make them a sawtooth development, they're linear. So if you can master a parallel parking maneuver, then you should be able to pull into those parking spaces without having to now illuminate for 29th Street and up through Skeens Lane with the headlights of your car pulling in. I could go on. I honestly could. I've got notes here that'll take me.
Well,
far beyond
yes, sir, you've
5
reached your 5 minutes in any event, so it's a good point. Okay, thank you, Mr. Roy. Let's hear, we have one more speaker from 3450 Lakeshore, Tim Dobson.
So 1 second, Mr. Chair. I think I have Tim Dobson on 2 different applications here, so I'm going to try to WebEx first to see if it works. Mr. Dobson, hello? Hello, Mr. Dobson?
Yes.
Okay, so this WebEx, that one's not, that you are cutting out like you did in the sound check, so I believe I have you as caller number 19. So I'm going to try to unmute the telephone. Can you?
Well, I'd rather go on the phone because of the phone.
Oh, perfect. We
It's
can hear you
easier.
now. Thank you.
Okay. All right. I'm recommending refusal of this application.
Sir,
rather
sir,
than
can you
deferral.
first of all just state your name and your address and in relation to where 3450 Lakeshore? What type of?
Okay.
Yeah.
Tim Dobson, I reside at 3450 Lakeshore. I own a commercial property also at 3448 Lakeshore under Dobson Design.
Okay.
So I've been following the 3418 application for some years, and I've had objections to that development. There's been changes to that development. These 9 spaces in question are part of those changes. But the presenter for Eden Oaks mentioned that the ground floor of 3418 was originally ground level parking with no commercial, with ugly metal grills facing Lakeshore Boulevard, completely against the avenues plan for the area, and Planning Department rejected that. They've made some modifications, but one of those modifications are they're still putting ground level parking on 3418 and disguising it with like posters in glass windows. So one of the modifications they've made is underground parking. Part of my objection is that these 9 spaces in question should be accommodated with an additional 1 level of underground parking at their expense, and keep it off of Skeens Lane, or try to buy Skeens Lane from the city, which is a whole other process, or buy a budding property on Lakeshore Boulevard West to accommodate their parking requirements. So it's clear they have not assembled sufficient enough land to accommodate the required parking. The applicant also mentioned about the residents on Skeens Lane possibly using the parking spaces that are existing, which for all intents and purposes appear to be public parking, even though they're on private land. The Skeens Lane residents, as a condominium corporation, does have their own visitor parking space in the north end. So they have accommodated on their own parcel the required visitor parking, and it's up to Eden Oaks, by the same token, to accommodate their required visitor parking on the 3418 parcel. And it appears that they just don't have enough land for the scale of development they're trying to squeeze on that property. And so they essentially need more land, or they need to go deeper underground to accommodate the required parking. In addition, for what they're proposing, having that unconnected with Skeens Lane being a public laneway, separating them, does create a dangerous precedent for future land development applications where people will point to this as a precedent. And I think that the committee should be cautioned about that. Currently, Skeens Lane is used as a bypass, a traffic bypass for all the traffic congestion, particularly with the streetcars, causing backups. And so there's regularly people speeding from the library on 32nd Street to 29th Street or 28th Street, all through Skeens Lane and through the parking lot of the dollar store that's there. So the residents of Skeens Lane are already experiencing people from Lakeshore Boulevard using the Skeens Lane east-west portion as a bypass and that will be exacerbated with this parking. But in addition, if these parking spaces are here, particularly angled parking, as soon as people back up from an angled parking, you're causing traffic accidents, which happens a lot on the south side of Lakeshore Boulevard with the current angled parking. So that would be another caution on this. So in summary, I believe that 3418 Eden Oaks development requires more land to accommodate the required parking spaces. And as you've already seen from the planning department, they've already been granted variances on parking reduction, and yet they're still wanting more.
Yeah.
So I think they've got to either redo their whole development plan to accommodate that required parking, particularly with going down an additional level. And I believe some of their tenant or occupant parking is on the ground floor, disguised by windows, and only a portion of the ground floor is commercial. And that commercial is actually facing 29th Street. It's not even facing Lakeshore Boulevard, which is, again, incongruent with the general character of the Long Branch business improvement area. So I recommend refusal of this rather than a deferral, and that the applicant needs to basically redesign that site and or maybe get more land to solve the problem.
Yeah. Is that already built? Or could they add another level of underground on their property?
No, nothing's built because the site is empty.
Yeah. Well,
so it's all on paper.
I see. Okay, so you're right. So the question is, as you've been speaking, I've been reading the decision before the tribunal. Let's see, it was LPAT, and you were a participant, and they asked to get less parking. They got it, and now they want to put 9 spots on this other property, which, as we stated at the outset, planning, it seems like a long time ago, was saying that need a OPA for this, and otherwise it should be refused. So does anyone have any comments for Mr. Dobson, who's, I guess you've been involved with this for quite some time, because it looks like
many years.
You were the party referred to extensively in the LPAT decision. And otherwise, let's go back from Glenn Willings to respond to all these concerns and make a decision on this. Mr. Willings, please tell us why you can't just go down and do another level if now you decided, your clients decided now they want more parking, even though they asked for a parking reduction and got it.
Yeah. And through you, it's not an easy answer. It's something I would certainly discuss with my client as well as the architect. What has been lost, I think, on the discussion is that these parking spaces, actually, a lot of them exist. And the comments of the gentleman about them being angled versus parallel, like that's a discussion item that we could certainly engage with the community on.
Right now, the discussion is these 9 spots, yes or no, or defer. We're not worried now about whether it's going to be sawtooth or parallel, or the issue is, you read an application for these 9 supplemental spots on another property, and that's what's before us. Yes,
sir, we're not bringing an official. We're not bringing an official plan amendment forward. So the answer is say no.
Okay. So the question is, the committee has to decide whether you should have these 9 spots, which are supplemental spots, not required spots, following a hearing where your client agreed to have less parking spots, and the issue about what you'd have to do that. So let's see if committee members have any further questions. Unless
Mr. Chairman, can I just clarify one thing,
Sure.
Mr. Chairman? I just want to make sure the committee understands that we comply with the parking that was supported by the variance that went to LPAT. So our position is it not better to grant some additional parking and sort of deal with a potential future situation that might not be good? Like I think that's kind of been lost. We're not asking for a parking variance here.
I understand.
We're asking for supplemental parking.
That's exactly what makes it worse, because you actually requested, your client, not 2 years ago, went to LPAT and requested a reduction in parking, which they got, and they made these arguments, oh, it's 1 bedrooms, it's this, it's that, there's less need for parking, and now you want to put 9 spots after 2 years ago. You asked for parking reduction, you now want more parking, and you want to do it on a separate property. And at the peril and the inconvenience and the disruption of all those people who, including Mr. Dobson, who was involved with that hearing, by now having parking on this other lot. So I think it's very clear what's before us. Let's see if there's any follow-up questions, or we have to take it into committee for a decision. As you said, we're way behind, or I think Mr. Dobson said that, Mr. Roy said that.
I've got a question and sort of a comment. I mean, really, what you're asking for is 4 additional spaces, because you already have 5, correct?
That's correct, sir.
Right, so really you're asking for 4 additional spaces. And when you look at the way that they're configured right now, you could probably get another 2 in there just by reconfiguring the landscaping. So I'm confused by this application.
Yeah, Mr. Chairman, that's why I had asked in my presentation, it would be helpful to know from the residents whether they had concerns with the existing parking. I think one of the residents mentioned that Skeens Lane has their own parking. Well, who's using that parking if this building is not even built and they're occupied? You can see that on Google Earth. There's 5 spaces within those 5 parking spaces. Like, who's using that? It's got to be somebody on Skeens Lane. So it is a request for 4 additional spaces.
So I'm confused now. Why is there not 9 and only 4? What about the other 5? Are the 5
Because
right?
5 already exist.
But they may not be they exist on what property? On 0 Skeens?
Yeah.
But are they
yes
as of right, or is this part of this application?
It's part of this application, sir. Yeah.
And
9 spots.
And how
those
would
5 spaces have been there for years?
Yeah,
and,
but
and they've been used for
it doesn't mean
years.
they've been used for years and they've been used for years, but they still may be part of this application because.
So where's
all
the
9
impact?
of them need to be. You want to use 9, 5, and 4.
I think the impact, what I'm hearing from the residents, the impact for them is not the existing 5 spaces, but the proposed 4 spaces, which will be on a different part of that lane altogether.
Okay. But they are both on 0 Skeens Lane.
Well, yes, but really, there's a laneway and then there's an access way to the townhouse development, and they're both named the same thing. That's the problem. But they're really 2 separate streets.
Okay. So is someone ready to make a motion?
Mr. Chair, the subject lands are designated neighborhoods in the official plan. The neighborhoods designation does not allow parking for adjacent or nearby mixed-use areas. The lands are zoned residential townhouses. The residential townhouse zone does not allow parking other than parking exclusive to the townhouse units, not as what is being proposed. I believe our hands are tied on this application, even if we were overwhelmingly supportive of it. The fact is, this proposal does not conform to the official plan and does not comply with the zoning bylaw. Those are 2 significant tests that we must address. I feel it fails on both counts, and I recommend refusal.
Thank you, Mr. Taylor, for that well-reasoned motion. Seconded for that, Mr. Kamarick, and as always, since all in favor, application is unanimously refused. Thank you, Mr. Wellings, and thank you, neighbors.
Okay.
Item
Yeah,
number
thank you,
15.
committee, for your time.
Okay, good luck. Item number 15 is 87 HILLCROFT Drive. This again was deferred from the September 15, 2020 hearing. We have, it's for a detached dwelling with an attached garage with 6 variances. We have a site-specific zoning bylaw, an applicant submission, an arborist report. Planning advises they have no further concerns regarding the October submission. And yeah, we had a previous planning refusal and objections. So the speaker registered for this is Ian Robertson, as well as the neighbor at 85 HILLCROFT, Adam Barses. Mr. Robertson?
Good afternoon, Mr. Chair. How are you?
Good afternoon.
So,
So this matter
we
was
have-
adjourned back in, deferred back in back in September. And you're back here. There's also urban forestry is looking for condition number 1. So can you tell us what's transpired since this matter was deferred?
Yes, I can. We've actually held a public meeting or community meeting for the residents who had concerns after the last meeting at the address in question. We spoke to 6 or 7 individuals who previously had written letters of objection or had concerns. And following that discussion, we had further discussions with planning and made a number of concessions from the previous application, including reduction in coverage, GFA, height, length.
Yes.
And we're able to accommodate all but one of those individuals. The household adjacent to us at 85 HILLCROFT still has some concerns, but everybody else felt that we made an effort to bring down the size and mass of this dwelling to their liking, as did planning, as you can see by their recommendation of support. Through this whole process with planning, the clients had continued to speak with residents where possible to try and get them on board. And as I mentioned, all but one have done such a thing. So
Yep.
I'm happy to answer any questions
Okay.
you, the committee, have or the neighbor.
Okay, so unless someone has any questions at this point, let's hear from the neighbor. We do have the planning memo for information purposes, which goes through the history and indicates and lists the 4 reductions you've made, which they now feel is in keeping and they no longer have concerns. So let's hear from the neighbor at 85, and you'll have a chance to respond. Mr. Barsis? I'm not sure.
Good afternoon, Mr. Chairman.
Yes, good afternoon, sir.
Good afternoon. My name is Adam Barsz, and I'm living at 85 HILLCROFT. And as you can see, we objecting to the application for the variances. The truth is that we spoke with the owners who are going to build the house a few times, and we raised our concerns, and these concerns were not taken under the advice.
Yes.
And we're looking at the situation where we know that the minor variance doesn't have mathematical definition. However, in this case, the floor space index exceeds by 36% the allowable bylaw, which is 0.5, and in this case, this new application asks for 0.68, which is 36% larger. Our biggest concern is that the length of the house. The proposed dwelling right now will be 18 meters. The house itself will be 14.5 meters plus 3 meters of raised covered porch. Our house is only 11.5 meters. So, and we have a small deck at the back of the house. So every time right now, if we will go outside, we will be facing a wall, a brick wall, because if you can see the way how the plans of the house, it is a brick house. So we will be facing a brick wall of 3.5 meters length and 10 meters high. It's not only that, but if you, on the plans, I can see that the fireplace vent is at the back of the house, and it will go directly to, because it will be that extension of the house. So that vent will go directly to our deck. So every time the neighbors will use the fireplace and we will be outside, we will face the vent, and it is going to be gas fireplace. So the fumes from the gas, they will go directly to our deck because of that extension of the house. The other big concern is that we have an 8-year-old tree at the back of our house, which is a bylaw protected. And the length of the house, if the house is going to be built according to the plans, we talked to arborist from Dave, which is a company used by the city quite often, and they said that because of the big canopy of the tree roots will be also the house will cut into the tree roots, which could affect the health of the tree. That also, not only that, but there are branches of the tree which goes on the neighbor side, and the neighbor will, to build the house that of this size, that length and that height, they will have to trim those branches, which are really big branches. That could affect the whole balance of the tree, and the tree could be destroyed. Another, what we also concerned that the biggest thing is that 85 HILLCROFT and 89 HILLCROFT, which is on the other side of the house, they are brand new houses. Like our house is 10 years old. We bought the house 10 years ago. Now at 89 HILLCROFT, they just built the house, they just moved in. Both houses are of the size between 250 to 270 square meters. This house is proposed 318 square meters. So what we want the house be aligned at the back with our houses and not going much farther than our house. I understand that there are in the neighborhood houses with the floor space index of 0.67, and the city allowed for those. However, none of those houses was built between two new houses. We're going to live in this house for another 10, 15, 20, maybe 30 years. I don't know when I'm going to die. And we will be facing that wall and that house for the next 30 years. And our house is built according to the bylaw. Why other people cannot do the same thing? And one more
Sir,
thing.
can you please try to wrap up because you're over 5 minutes? Thank you.
Yes, and one more thing. So what we propose the house not longer, the length of the house to be not longer than 12 meters, which is the 89 HILLCROFT. Ours is 11.5. And I also wrote it in my letter. There is a court case, and the court case from '94, and that court case says that minor variance is a privilege, yes, but it shouldn't be a nuisance for others. And in this case, especially because of the effect on the tree, on the vent, which will go directly to our deck.
Sir, can you please wrap up? Thank you.
And that we strongly object, and we ask the committee to reject the application.
Thank you, sir.
Very much.
Thank you. And we have your letter and your wife's letter, I assume, as well. That they're both dated.
Yes.
And with
Yes,
pictures
she couldn't come. She works.
Yeah,
in a
that's
public
okay.
health
You're only allowed one person to speak from household anyway, so
yeah,
you did a good job. Okay, so we can go back to Mr. Robertson to respond to your concerns. And does anyone have any questions for the neighbor at 85 before we do that? Okay, so Mr. Robertson.
Yeah, I can address some of those concerns.
So just
one of them being,
first of all, just to clarify the length or the depth. So you're about a meter over, I think, right? The neighbor was saying he doesn't want you to go deeper, but you're only a meter over in the rear.
So actually, our depth at 18.05 meters.
Yes.
Is it's only over by a meter, but those last 3 meters are of a porch that's below fence line. It's like 8 risers off of grade.
Okay.
And it's not covered, so it's not a visual impact.
So it's only being counted because there's a cold room below the rear porch.
That's right.
Okay.
Yeah. So the actual wall length to him is 14.99 meters, where we could actually be 17 meters, assuming we complied or got variances for other variances. But the coverage, we were only asking for 1% increase. And so that, in the building length, I don't think those impacts are that great. As far as venting and that go, there's no control into where or no governance as to where one vents, furnace, hot water tank, or fireplace. All would be similar as a gas-powered appliances. And I'm sure he probably has his venting of his on the opposite side of his house, or possibly on our side, just similar impact. So those aren't really concerns that the committee would discuss. As far as the arborist report goes, I don't think he submitted an arborist report to his presentation there, so I couldn't really speak to what it was, but we had ours done, and that was submitted to forestry with their acknowledgement and approval for their condition number 1. So
Yes.
the impact of the trees on our lots and adjacent lots would be within that report. And with approval. So I think those are the things he was mentioning previously, as far as his concerns for the property. But I think the biggest one is probably building length. I'd just like to note that the fact that we are on the north side of his property, our building length, although he would have an impact of that wall that's there, and we are allowed to go 2 meters longer than we have proposed, we actually don't have any impact from a sun point of view with regards to this length, due to the fact we are on the north side of him, sun rising in the east and falling in the west. So there actually is no real impact from a massing, size, or scale point of view either. Just thought I'd add that.
Okay, thank you, Mr. Robertson. Committee members, any questions for Mr. Robertson or for the neighbor, or someone ready to make a motion?
Question for Mr. Robertson. I'm assuming you would not be opposed if, should we approve this, that we were to tie it to an elevation with regards to the setback, the length being tied to, no?
Planning's actually asking for that.
Oh, they are?
Yeah.
Okay, sorry, got it.
Oh,
Yes,
sorry.
we're in agreement with that.
Sorry, my mistake. I'm looking at the next application on Marquis. No, planning just said no further comments. My mistake, sorry. So
just to address that building length issue, would you be opposed to us tying it to some plans or site plans or elevations?
No, we wouldn't have any objection to that.
Okay, thank you.
Okay. Good question. Anyone else have any questions, or is someone ready to make a motion? And there is urban forestry number 1.
I guess I'll perfect that a little bit. I'd like to propose approval, seeing that I do believe this is minor and it does meet the tests. However, I would like to make it subject to a couple of conditions. Forestry condition number 1, and to address the length of the house issue, if we could tie it to, would it be the south elevation then? Site plan. Okay, let's do it to site plan then.
Okay. Thank you for that motion. Seconder for that motion? Mr. Taylor? Oh, okay. Laura? All in favor? Okay, you have unanimous approval based on that motion, subject to those conditions. Thank you, and thank you, neighbor.
Thank you, Mr. Chair.
Our next application is item number 16, 14 Marquis Avenue.
Good afternoon, Mr. Chair.
And
committee
good
members.
afternoon. We have registered a speaker on this, Adib Carl Gubril, and you're the only speaker. Just let me quickly introduce the application. This is for a new detached dwelling with an attached garage, and there are 5 variances. Transportation has no objection. Planning, this is the one I was looking at, would like a condition of being built substantially in accordance with the revised plans dated October 20th. And we have forestry conditions 2, 3, and 5. This was deferred from October 6th to make changes. And we have something that appears to be undated. We have 7 letters. Oh, you're right. There appears to be 7 letters of opposition, but as is often the case with these deferred applications, it's hard to know which ones are current and which ones are old letters that were sent in prior to the October 6th hearing. But that is what we have.
Thank you, Mr. Chair.
So let's
Indeed,
hear
that is what
from
we have.
Mr. Deeb. Would you like to add anything? What I had to say?
I can, right on. I definitely would like to add something. If Angela, Adam, or Paul, I'm not sure who's running the presentation, if you can pull up mine. And while that's happening, Mr. Chair, I must commend you for the pronunciation of my name. You got it spot on. But for the rest of this conversation, you may call me Carl if that's easier for everybody involved.
Okay.
So as you guys know, we've had some considerable conversations individually with our neighbors, and I see it's almost coming up. Yep, and of course with city planning. We're very excited about this. We thank you for the opportunity to talk about our home. My wife here is nudging me. She's very excited about this. We've been looking at the Kingsway for more than 14 years, and we're excited at the opportunity to perhaps be able to finally move in. All right, so after considerable conversation with city planning and per their guidance, we have moved our design to be set back from both east and west boundaries by 0.9 meters. And the recommendation was for that second story platform, or third story, depending on what you think, or 2.5 story, if that's probably the most apt description, to be at 9.2 meters squared. We decided to go for a size of 6.89 as a goodwill gesture to our neighbors.
Okay.
And finally, the recommendation was from city planning to aim for an FSI of 0.88, which is what we have done. Okay, so that's the floor space index. And I can talk a little bit more about this.
Right. So I think that, sir, the situation is very succinctly referred to in the revised staff report dated November the 12th. They go through what you were asking for and the changes you've made, which you have now reiterated, and you've gone through those and said that in addition to be built, they want a condition of being built substantially in accordance with the plans, as I stated at the outset. So thank you for doing that. I think, let's see if committee members have any further questions or if they're ready to bring a motion. No, there's no one else speaking on this.
Very well. I mean, I'm happy to sort of walk you along Marquis Avenue, if so desired. Shall I continue with my presentation? Do you need to see more?
I don't think we need to hear more further from you, sir. It's all stated. You've already gone through that, and it's we have your supporting materials that you've supplied with all the photos and maps. So you've done a very. Are you a planner?
No, sir, but I am an engineer.
Okay,
so
so
I have that against me.
yeah, you've done a very professional looking job of your presentation.
Thank you.
Very well.
I do have a question. I'm of the applicant. Are you okay with urban forestry conditions number 2 and number 3?
Well, we acknowledge the report that that we have to apply for an injury permit to injure a tree. We also spoken with 2 arborists, and I believe the sort of the conventional wisdom is that tree unfortunately was planted too close to the original foundation, and its roots may be already impacted as a result. The arborist that we're planning to go with has said, perhaps in not such words, that irrespective of what happens next, unfortunately that tree cannot be saved. Now, we understand that, and we've spent the weekend, my wife and I, Georgia and I, looking at the sort of urban forestry brochure for what kind of trees we can plant, and we already have 3 in mind. If that's a good enough explanation.
Yes, that's fine. Thank you.
If I may, I'd like to add that we maintain ample green space both in our front and our backyards, and that's distinct on the street, and that is it's done specifically in respect for maintaining privacy. But not only that, but to maintain the original intent of the Kingsway as conceived by the architect 100 years ago, Holmes Smith.
Conditions 2 and 3, correct? So let's see if someone's ready to make a motion.
I can give it a shot. Prepared to move approval of the variances because I believe they are minor in nature with the condition that community planning has laid out, that it be built substantially in accordance with revised plans submitted October 20th, and also with urban forestry conditions number 2 and number 3.
Thank you. Seconded for Ms. Alderson's motion. Mr. Taylor, all in favor? Unanimous approval. Thank you, sir, and good luck with your house.
Thank you very much indeed.
Thank you.
Have a good day.
Okay, item number 17 is 40 Dalbeattie Avenue. This was deferred from the October 6th hearing and is an application for a detached dwelling with an attached garage with 5 variances. There's a cover letter, ravines, we have revised drawings. The underground garage and second floor rear platform have been eliminated. We've been advised planning is, would like it tied to be substantial in accordance with the site plan in the east elevation dated November 2nd. And we're advised that 2 of the variances are not required. And we have 14 letters of support and urban forestry condition number 1. Registered to speak is Mr. Bob Green, agent. Mr. Green.
Thank you very much, and I appreciate your patience going through this long agenda. So just very briefly, as you've already mentioned, subsequent to the referral, we've had discussions with the city of planner, Anita Coleman, and the entire underground garage was deleted, as well as the second floor rear platform. We submitted revised drawings to the Committee of Adjustment reflecting these changes. As was not possible to, due to timing to get a revised zoning notice, we submitted a waiver and corresponding list of variances to the Committee of Adjustment. Okay. Subsequent to submitting the list of variances, we were sent an updated notice, zoning notice by the City of Toronto Examiner based on the revised plans, at which time was determined that variances relating to item 2 and 3, depth and length, were in fact not required. I'm requesting that the committee delete these 2 variances at today's hearing. Okay. It was also determined that the actual coverage would be 34.98%, which is less than the required 36.23%. And I'm accordingly requesting the committee lower the requested coverage to 34.98%.
So variance 1 changes from 36.23 to?
34.98.
Okay, and variances 2 and 3 are eliminated.
That's correct. And
Can we get what the coverage is in square meters, please?
Hang on a second, I gotta go to her notice. Sorry, I gotta find the zoning notice that she sent. Uh, 325.04 square meters.
Okay.
And that's corresponding to the 34.98.
Right, and we have those are the 3 changes.
Those are the 3 changes. The other 2 variances would
and the revised plans are dated November the 2nd, correct? Because if they're going to be tied to the site plan in the easterly elevation.
That's correct.
Okay, so let's see if someone's ready to bring a motion. There's no one here in opposition.
I find the application to meet the 4 tests and would therefore like to move approval as amended. I'm assuming I don't need to go through all the amendments.
Yeah, the reduction to variance 1 and 2 and 3, Madam Secretary.
2 and 3 eliminated, reduction to variance 1.
Correct.
And that it be subject to forestry condition number 1 and subject to, and it being substantially in accordance with the drawing submitted November the 2nd, 2020.
Right, with respect to site plan and easterly elevation. Thank you, Mr. Comeric, for that motion. Is there someone, Ms. Alderson has her hand up, because there's a 2-second delay, so you have to get in faster with your motions and seconding. And all in favor? Unanimous approval. Okay, thank you, Mr. Green. You have your approval.
Thank you very much. Appreciate it.
Thank you. Okay, we have 2 more applications in the morning session. The next one is item number 1819 Pheasant Lane. This is an application for a detached dwelling with an attached garage and a cabana in the rear yard. There are 7 variances. There's an arborist report, urban forestry is requesting conditions 1 and 2. And this matter was deferred again from October 6th to correct the notice and discuss with neighbors. And okay. Speakers on this application are Ian Andres, the agent, as well as the neighbors at 8, 21, and 17 Pheasant Lane. Mr. Andres.
Thank you very much. Good afternoon, Mr. Chair and members of the committee. My name is Ian Andres. I'm a solicitor with Goodmans, and I'm here on behalf of the applicants and the owners of 19 Pheasant Lane. As you said, this application was originally scheduled on October 6th. City planning had reviewed the original proposal and not raised any concerns, but there were some concerns raised by neighbors and by urban forestry at the time. As such, our client decided to defer to allow for more time for discussions, as you said. I understand that further discussions were held primarily spearheaded by the project architect, Mr. Andrew Dean, with the 2 adjacent neighbors, as well as with urban forestry staff. I think our clients spoke directly with Ms. Bechtold as well, who's one of the adjacent neighbors. And my understanding is that those discussions went quite well. I believe, although I guess we'll wait to hear what the neighbors say, but it was my understanding that Mr. Palumbo was content with the revised changes. I'm not sure exactly where Ms. Bechtold landed, so I'll wait to hear what she has to say. But in a nutshell, the discussions resulted in a number of significant revisions to the plans, including the elimination of several variances related to rear balcony area, the cabana setback, the front yard setback, and the chimney width. And there was also reductions in several other variances, virtually all of them, the gross floor area, the coverage, side yard setback, overall height, and main wall height. And the revised plans also now ensure that all of the trees in the front yard and the boulevard and the side yards are proposed to be retained with appropriate tree protection zones. And as you noted, urban forestry conditions would be required, which is fine. So to summarize the proposal in a nutshell, there's 7 variances proposed. An increase in permitted coverage from 22% to 29.5%, increase in density from 0.28 times the lot area to 0.39, a decrease in the minimum side yard setbacks. On the west side, it would go from 6 meters to 3.7. On the east side, from 6 meters down to 5.01. Although I would note that the required aggregate setback combining the 2 sides is achieved. There's an increase in side exterior wall, main wall height from 7 to 7.21 meters. An increase sought for overall building height under bylaw 569 from 8.6 meters to 9.5. An increase in overall height under the Etobicoke bylaw from 6.5 meters measured to the bottom of the roof to 9.5 meters. And that's because this, under the old bylaw, this project is considered a flat roof building, even though there is significant slope to the roof. And then finally, there's an increase in the front platform encroachment from 2.5 meters to 3.91. So for the reasons which I'll describe, it's our respectful submission that the proposal satisfies the 4 tests for each of the variances, and that this new dwelling will fit harmoniously within the streetscape and established character. So the subject property is located in Thorncrest Village. As I'm sure you know, it's a mature and stable residential area north of Rathburn between Kipling and Islington. Subject property is a 29-meter wide lot, mid-block on the south side of Pheasant Lane, neighboring single detached dwellings on each side. The streetscape includes lots of mature trees and large landscape front yards. There's no sidewalks or curbs on either side of the street. And the surrounding properties are all wide lots with mix of old and new dwellings of varying architectural styles, most of which are large 2-story houses, especially the newer ones. So the existing dwelling to be demolished has the same side yard setback on the east side as what is proposed, which is next to a large oak tree. And on the west side, the garage is actually set closer to the side lot line than what's proposed with the new house. So to that extent, the condition would be improved. With the exception of the front porch, a 2.5-meter wide strip along the west side of the house and a small portion at the northeast corner of the house, the dwelling fits entirely within the as-of-right building footprint. And I know there was a presentation package sent in by Mr. Dean, the architect. I don't know if you have that in front of you, but it illustrates on the site plan what I'm commenting about. That's great, thank you. So if we go to the second or third page, we can see on the, perhaps the third page is a little perfect. That's good. So the red line shows the as-of-right building footprint, and what I was just referring to is in the bottom left corner, you can see there's a little bit of an area sticking out near the tree, and that's the extent of the side yard protrusion there. And on the other side, the entire length of the house goes beyond the permitted side yard setback by about 2.5 meters there. But that has been pulled back from the original scheme as a result of some of the neighbors' questions. So as I mentioned, city planning staff have indicated that they have no concerns with either the original proposal or this revised proposal. Urban Forestry had some concerns with the trees in the side yards, but to my understanding, those have now been addressed through the submission of the arborist report and discussions with Urban Forestry staff. And the neighbors, there were several opposition letters sent in prior to the original hearing. Some of those letters were just objecting to the short period of time allowed for comment, but some were also raising substantive issues, and our clients took these concerns to heart and have engaged in extensive dialogue since the deferral, and several concessions were made. So the main concessions were reducing the overall height of the dwelling by over a foot, about 40 centimeters, by pulling in the west side wall by 4 feet to preserve the trees and achieve a greater site yard setback, by relocating the cabana away from the lot line so that no setback variance is required anymore, by enclosing the rear second floor space so there's no longer a balcony variance required, and by removing the non-compliant chimney. So it's our submission that the requested variances are desirable because they respect the existing physical character of the neighborhood and they reinforce its stability through reinvestment. The intent and purpose of the official plan is maintained. The proposal is fully compliant with the built form and neighborhood's policies. It fits with the streetscape. The footprint and massing are appropriate for this mid-block lot, and they respond comfortably to the neighborhood lot and house patterns.
Okay.
And the intent and purpose of
Can
the
you
zoning
please wrap
bylaw-
up, sir?
Yes, the intent and purpose of the zoning bylaw is also maintained. You can see here there's a few charts which show recent approvals, but beyond that, the restrictive zoning standards for this lot, which date back to 1988, are more restrictive than normally permitted in the RD zone category. But nevertheless, what's proposed is entirely within the range of what's been recently approved and does not result in any adverse impact. So for all those reasons, we respectfully request that the committee approve the variances.
Okay, thank you. Any questions for Mr. Andres before we move on to the neighbors? First neighbor listed is 8 Pheasant Lane. It's across the street. Ross Sinclair. Mr. Sinclair?
Yes. Yes, I'm here. Can you hear me?
Yes, we can, loud and clear. Can you please let us know
Good.
what your concerns are in relation to?
Yeah, I live at-
You're at number 8, correct?
I'm at 8 Pheasant Lane, so I'm across the street on the north side and a few houses down. Let me give you a bit of background because I have had extensive discussions and communications with Tony Palumbo and Joanna Bruchtold, as well as several other neighbors, including John Minister, who is at 6 Pheasant Lane. And
okay, anyway, let us hear what the neighbors at 21 and 2017 are waiting to speak after you speak, so they're
I understand that.
themselves. So just let us know what your concerns are, because you're speaking for yourself, and I don't have anything in writing that you're acting for someone else. So please let us know what your concerns are.
My concerns are that the changes that have been made from the original proposal, for which there was significant objection, are the only thing that represents sort of something that is minor in my view. The biggest issues with the property is that it's basically too big for the lot. It substantially exceeds the lot coverage by 34%. It substantially exceeds the gross floor area by about 38%. It is almost 11% over the height limit. In addition, it has numerous setbacks variance to deal with. I have done a detailed review of, for the last 15 years, of all of the approvals along Pheasant Lane, and I could submit that to you. I didn't have a chance to submit them beforehand because the information relating to
Yeah,
the
sorry,
submissions that the
you can't add
architect
anything
made.
at this point. You can't add it. We have what's
Okay,
before us.
okay, but you can take
But-
my sort of verbal
Yeah, okay,
representations.
just-
What I'm basically saying is that there has not been any approvals of a property that exceeds those 3 variances at all in the last 15 years. While there are examples that they have given in their submission of properties that may have been close to or exceeded each individual ones, in those cases they were generally exceptions because of existing renovations, or the property was a 1-story property, or other circumstances. But this would be an absolute first for Pheasant Lane as well as Thorncrest Village. The zoning requirements permit, and many people have built properties in the last 2.5 years along Pheasant Lane that have been very good additions to the neighborhood, and they have generally had no variances, or 1 or 2, generally something relating to floor space or a few setbacks. I would have to characterize this as a very unusual addition to the neighborhood. It's exceedingly large, as is demonstrated by the fact that it exceeds coverage, floor area, and height. The changes they made, having received all the various objections, are relatively minor. I would refer to them as tweaks of the original zoning requirements, and most of the, my significant concern is that there is a property that is likely to be redeveloped because it was sold recently next to me at 10 Pheasant Lane. While that property isn't in question here, is that my concerns are anyone building something like this next to me, I would do what I'm doing now in terms of strenuously objecting to the creation of a property which far exceeds the requirements and would hover over neighbors and not be in the spirit of what was intended through the zoning requirements or what has been built in Thorncrest Village. That's
Okay,
all.
thank you, sir. That was 8 Pheasant Lane. Now we'll hear from the neighbor at 21 Pheasant Lane, right next door, Joanna Bechtold.
Yes, good morning, ladies and gentlemen. I agree with Ross that it is not in the character of the village. Now, many of us have paid a premium to be in this village because of its extraordinary nature and privacy. And to have somebody come in and then with disregard, flagrantly sidestepping the bylaws and putting on something that has so many variances and so much larger. There's been, as Mr. Ross, as Ross said, there's been the occasional floor area being exceeded, or coverage being exceeded, or height being exceeded, but never all 3. So it is a very, very large impact. And for 75 years, those of us who have lived here have stood up to keep the bylaws and to keep the community as it is. Now, the architect was saying that there are being extensive dialogue and discussions. I don't know with whom. I reached out and sent him an email making a compromise, and was told, no, that wouldn't work. And my second email was ignored. I was then able somehow to get the phone number of Mrs. Davis, and we had a discussion on the phone, and I posited the ideas I had and my concessions, and but they never got back to me. So I don't see where this dialogue and discussion has occurred, and that it's not the way we do things here in the village. And I would add that the house, although it's very symmetrical, etc., but it is very large, it's very imposing, and it will dominate the streetscape. And so it's an imposition of the neighbors and all the passersby. And as Mr. Sinclair also mentioned, why I really do wonder about what the precedents will be. This will eventually just become a place where people want to have big houses rather than honor the ambiance of the village. Thank you.
Thank you. Any questions of Mrs. Berchtold before?
Can I add one more thing? The architect said that the garage was actually closer to the lot line than what they now suggest, and that's true. But I would point out that the garage is set back as 1 car length, and in front of the garage is a strip of land and a driveway and then a walkway and then a part of the house that sticks out. So it's a very, very big, wide open space. And so when this house is built, all the way along from the front of my house to the back, it will be quite close and quite an imposition. Thank you.
Thank you. Okay, does anyone have any questions for Mrs. Bechtold before we go on to Mr. Palumbo next or on the other side of number 17? Okay, Mr. Palumbo.
Hi, my name is Anthony Palumbo. I reside at 17 Pheasant Lane, and that abuts on the east side of number 19. And I did reach out to the architect, and initially, I think, wrote one of the first letters of objection.
Yes.
And overall, then I felt that many of the variances were not minor, and collectively, they were not minor. Since then, the architect, and as you've heard, they've scaled back a little bit and eliminated some of the variances. And the ones that remain, when I look at it and I listen to my neighbors, just to give you a perspective, my house is 4,425 square feet, and I've measured off the proposed dwelling at 6,250. So that's about 40% bigger than my house. That's the ground floor and the I guess the second floor. Mm-hmm. So that just to put it in perspective, and I think that's what the major issues are with my fellow neighbors, along with setting a precedent. And I think maybe that coverage issue, is the one to be addressed. I note that in the lot coverage it includes the front and back porch. So I have no idea what happens if you back out the front and back porch. I imagine that variance might drop. Yes. So I think that the house, there's no question that it's a massive house in terms of gross floor area, and the height, unfortunately, is above the bylaw. And those two issues are extremely major. You can see that the variance is a material variance, and you just can't argue against that. Mathematically, visually, any way you want to cut it. I think that's what I'd like to say about it. To their credit, we recognize that they did make and eliminate some of the variance, but I think a more healthy dialogue would have perhaps, gotten us at a different place. And, I would still like to see that so that the parties could maybe find some sort of middle ground. But as it stands now, I think you're looking at an extremely major variance. And it's, I've been listening all day, and one of the things that struck out to me is that person who said to me that there's case law, that a minor variance is a privilege and not a right. And that just struck me as being, it just struck me. So I'd like to end on that note. And those are my thoughts for the committee. Thank you very much for listening, and thank you for your time.
Thank you, Mr. Palumbo. I also that was the case of the Asaraf case versus the city, which someone cited in an earlier application you were listening to. And if you look at that, you'd wonder why the city has, thousands of applications, because in reality, I always say it's a privilege and a right with respect to consents. When you look to split a lot and then put an oversized home, that I think is, that's one of those situations. But you're right, there is that case law, there is other case law as well. And having said that, there's still many applications made, which you could argue that most of them are a matter of, a privilege. And, it's an issue of the trend to bigger and bigger homes on these very valuable lots in the city. Both small lots and large lots.
And I'm all for. Hi, and I'm all for. I recognize that, and I'm for progress as well.
Yeah.
So I'm not stuck.
Yeah. I just noticed. Yeah, in the emails that have been floating around, it said afterwards that you were. And I'm not putting words in your mouth. The email from the architect did indicate that you had no further concerns, but
I said, I am supportive of both your initial and additional changes, and look forward to receiving the revised site plan. So I support, progress, and I viewed that as good progress. I suggested other changes.
Yeah.
And, overall, I'd like to see something built that satisfies the owners and my fellow neighbors.
Of course, that's always the best. Okay, thank you, Mr. Palumbo. Let's go back to Mr. Andres to respond to the concerns of the neighbors, and then we can bring it into committee for a decision. Okay? Mr. Andres, the floor is yours.
Not a right or an entitlement.
Sorry, you just kicked in now. Can you start over?
Sure. So I just wanted to start by acknowledging that variances are a privilege and not an entitlement. I think Ms. Bechtold called our actions here flagrant or something to that effect, which I would strenuously object to. Our clients have gone above and beyond to try to work with the neighbors here, primarily through the architect, but also through some direct discussions. And we followed the process, including accepting a deferral of the initial committee hearing. Our clients reached out to Ms. Bechtold on several occasions and have had several discussions with her, including some directly with the owners of the house to try to address her concerns. And the primary concern that Ms. Bechtold kept raising related to the height of the cabana, for which there's no variance being sought at all. So to that extent, our client was not interested in lowering the height of the cabana any further, but that's not even before you today. Otherwise, there were some other concerns raised by Ms. Bechtold that have through changes to the plans. And while it sounds like she's still not satisfied entirely, I think that our clients have made a very valiant effort to try to meet much of that. I must say Mr. Palumbo's comments come as a complete surprise to us. He wrote an email to Mr. Dean, the project architect, on October 9th, saying he was supportive of the original changes and the further changes. So from that day forward, it was our understanding that he no longer had concerns. Some of the comments this morning suggest otherwise, of course, but that's a complete surprise that we're blindsided by. What I'd also like to say is none of the objecting neighbors have pointed to any specific concerns or impacts resulting from this house. There's some concerns raised about alleged precedent that it would set and some esoteric concerns about the size of the house, but nobody has pointed to any specific impacts or problems in terms of neighbor adjacencies. The concerns raised by Mr. Sinclair are entirely hypothetical and speculative as they relate to what might happen at the house next door to him. That's obviously not before you today and not relevant. It's also not helpful to speak solely in percentage exceedances over the bylaw standards. As you know, Mr. Chair, members of the committee, the test of minor is not a numerical test, it's one of impact. And so speaking of what percentage the coverage exceeds the bylaw standard just doesn't really tell us very much. You have to look at how that coverage is deployed on the site and whether there's impacts resulting from it. And we, of course, submit that there's not. There have been many recent approvals on Pheasant Lane itself and in the broader neighborhood for greater height, for greater density, for greater coverage. The submission materials we've provided highlight the ones in closest proximity to the subject site. For height, there were 4 approvals recently above 9 meters on Pheasant Lane. 2 are at approximately 9.5 meters in building height. That's 34 and 49 Pheasant Lane. And there's one that went to 9.91 at 30 Pheasant Lane. And that house also had a very significant FSI variance as well. So there already are some precedents out there for this type of development. But I would also go back to note that planning staff have raised no concern whatsoever from what's being proposed here. And as I mentioned in my original submission, the bylaw standards here are much more restrictive than a typical RD zone, even though this is an RD zone. They date back 32 years to a bylaw that amendment that was made back then. And while I appreciate that the neighbors would like to enforce the standards from 32 years ago, you know, there has to be a considered evaluation of each application as it comes forward. And planning staff have looked at this application and seen no concerns. And my clients have tried really hard to address the neighbors' concerns and to make appropriate changes as a result of those. So Mr. Sinclair's house is over 100 meters away. Given all the trees on the street, you can't even see the subject property from his property. So any concerns about precedent, I really don't think should be the driving determination here. And if I say any more, I'll be repeating myself. So I would just say that in summary, that the neighbors' concerns, we've made a real concerted effort to try to address them, and we continue to believe that the 4 tests are very comfortably met with this proposal. Thank you.
Thank you, Mr. Andrus. Any questions for Mr. Andrus? I have one quick question. I think it was Ms. Bechtold, who mentioned, you know, people have gone for, you know, for height and for massing and for, but in this case, and you've pointed out other situations on Pheasant Lane in the wider neighborhood where there's been floor space index, there's been coverage, and there's been height. The question is, she's saying they're all together. Would you disagree with what she said? Is there, you know, combinations? I guess every application is on its own merits. But I believe that's
yes, absolutely. Right. So I'm just looking at the presentation materials we submitted, and one perfect example is number 30 Pheasant Lane, which had a coverage variance of 30.6% approved, and which had a FSI variance of, I think it says 58% approved, which is much higher than what's proposed here, and which had a height variance of 9.91.
Okay, so it's
each of those 3 is higher than what we're proposing. So there's a package of height and coverage variances and density variances that's actually more.
Okay, thank you.
Here.
I just wanted to clarify that. Okay, any further follow-up questions? We're going to take it into committee now. So any further last-minute comments, questions, or a motion? And we then have one more item still on our morning agenda.
Members, we need a motion.
Well, Mr. Chair, this is a neighborhood I'm quite familiar with. I was born not very far away from this neighborhood. And it's been in, as many neighborhoods in Toronto and Etobicoke, under transition. And it has become a very attractive, desirable neighborhood that has big lots that will contain and accommodate big homes. And I can remember back in the day when this area was developed, you couldn't put fences in, swimming pools, or even basements. So, yes, I'm 98 years old. So I don't have any difficulties with this at all. I think the house is quite reasonable for this neighborhood in today's terms. And I would recommend approval, subject to urban forestry conditions 1 and 2.
Thank you, Mr. Taylor. I have a seconder
I
to
can
that
certainly
motion.
second that motion.
Okay, thank
I
you.
can
Ms.
certainly
Armstrong.
second that motion.
Okay, all in favor? You have unanimous approval. Thank you, Mr. Andrus. Thank you, neighbors.
Okay, Mr. Chair, we're just running out of time on our first YouTube
Okay,
stream.
perhaps we can break now and do the item number 19 in the afternoon?
Do you want to make them wait?
Thank you very much, everyone.
Well, if we're gonna have to take 5 or 10 minutes to get down and resubmit, it makes sense to perhaps to do it now. If the neighbors, Mr. Hammond and the 2 neighbors on the last morning application wouldn't mind waiting if we're gonna take a brief break, that would seem to be most, unless you want to proceed, and then if
We're
you have to
just
stop
running
for
out
the
of
YouTube.
time.
So I'm saying
Yeah.
that's a 5-minute process? Or?
Some less than that, yeah.
Okay, so whatever you wish. I don't know with the other members. We've been sitting here since 9:30, so whether now is the time to take a break, or I don't want to have problems with the last people saying that we did something untoward and made them wait.
I don't want to have the applicant for number 19 wait. It looks like a very straightforward application, so I'm wondering if we can hear it quickly. There are no conditions.
Yeah, but there's two other speakers.
Three.
3 others. So 3? There's one on
There's
the other
one on the
page?
next-
Yeah, there's 3 speakers, so it's going to take a while.
Okay.
I agree. If it was an unopposed application, I would agree 100%.
So these are people in opposition then,
I would
who are
assume so.
speaking.
I would assume so. Right next door, we do have, I see someone on both other sides, 23.
Because all
I
I've
thought
got
it
here
saw
is 2 letters of support.
Yes, 23 is registered as a speaker. I realize we have support from 23 and 25, but we have 19 registered to speak as well as 34, 36th Street. So whatever anyone wants to do, I was just throwing up as a suggestion since it's already 1:45 and we haven't broken for lunch yet. So I'm standing with other people want to do. But if we have to change the YouTube.
Yeah, well then I guess we need to adjourn.
Okay, so
Yeah, we can work through. I don't know if you have to give, a short lunch break for the staff.
Okay, so for anyone participating on YouTube, we're ending this stream now. We'll be starting the 1 p.m., which is past 1 p.m. You can join that. We'll be doing sound check, but we'll be restarting the hearing at 2:40, okay? So item 19, whoever is here for 21 24th Street, you'll be the first item when we come back.
Is it, you want the 22, an hour for 55 minutes for the break? You want a 55-minute break? You said 22? 240?
That's what Barb said, 2:40. Yeah, 55 minutes.
Yeah. Okay, because we could do it less, but I guess. Okay, so we'll be back at 2:40, and if we can apologize to the people in item number 19.